Civil War. Okay. Okay.
Good morning.
Okay.
Good morning.
Are y'all ready?
Thank you. How you doing? Yes, sir.
County ready? Okay. Good morning, everyone. I am Christian Waugh. I'm the special master here, and I bring this June Citrus County Code Compliance hearing to order. At these hearings, we follow an agenda, one of which is posted outside. The first item on the agenda, as you might imagine, is the call to order. We just had that. Ma'am, go on. You can.
For land stuff?
Well, code compliance, if you,
Yes.
sure, why don't you come on in?
Thanks.
The second item on the agenda is the pledge to the flag, so I'd like to ask if you join me for that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. So the next item on the agenda is approving the minutes from the Wednesday, May 15th, 2024 hearing, which is basically a transcription of what happened at that hearing. I've reviewed the minutes. I have no proposed changes or modifications. Are there any objections or proposed changes to the minutes as currently formulated? All right, I don't hear any, so I'm going to go ahead and sign the minutes.
Staff update, abated, and continued cases are listed out front.
All right, thank you. Once again, everyone, good morning. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing today. What I am going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you'd pay attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case and I will allow the county to present its case first. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have the opportunity to present your case regarding the violation. I allow the county to present its case first because I don't know what the case is about until they tell me. But when you have your chance, that will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting whether a violation exists. If you don't contest that a violation exists, then I'll assume a factual basis for the violation and just ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others. You are by no means required to concede the case. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before any fine begins. You must abate the violation by that date that is fixed the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on your property. The county has the right to foreclose on that lien or seek a judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you may be responsible for additional costs. Is there any appeal order to demolish? All right, ladies and gentlemen, as you heard earlier, you do have the right to appeal any order that I do make today. Thank you very much.
First case on today's agenda, John T. Perez, case number 2024-284, Code Officer Julie Wilkinson, page 23 of your agenda. Expert on the case, Deborah Burns.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number CE 2024-00284, conflict with Central Water Facilities. Section 42-39B, conflict with Central Water Facilities. The address is 4168 West Bach Lane in Homosassa. The property owner is John T. Perez. I have good service via posting the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, copies of the notices from the utilities for water connection, 365 days, 270 days, 180 days, 90 days, and the final 30-day notice, and a copy of the signed certified mail return receipt for the 365-day notice. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
He's just-
Mr. Perez, are you here? Okay. Thank you. Without objection, what's been proposed as exhibits, I think A and B, is admitted as evidence. Please proceed.
On February 14th, 2024, I received this case for failure to connect to public water system and found that there is no permit to connect. A notice of violation was issued on March 6, 2024, and on April 25th, 2024, I conducted a corrective action inspection and found that no connection has been made and no waiver has been given. As of my final inspection on June 18th, 2024, there has not been a permit applied for, nor any contact regarding connecting to the central water system. I will now turn over this case to the expert, Deborah Burns.
Good morning.
Good morning. All right, the only contact I had is the daughter of Mr. Perez called in back in February of '23.
The what?
The daughter,
The daughter.
and asked about the cost and stated they were on a fixed income. We gave her the housing information, and we've never heard any contact since.
Okay. And they haven't submitted anything in writing in response to this?
No, nothing.
They haven't applied for any hardship kind of?
Nothing.
Okay. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for inspection.
Is there anyone from the public who wants to be heard on this case? I don't see anybody. This case has been pending for a long time. There've been a lot of notices. So what I'm going to do is I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, I'll adopt the county's recommendation of $50 per day. And
Thank you.
otherwise incorporate the standard order provisions. Thank you.
Thank you.
Next case on today's agenda, David Fiera, case number 2024-682, Code Officer Amy Becker, page 13 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Sir,
Sir,
can I
could you
step
stand?
down there? Sir, can you please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good
Please
morning,
state your
sir.
name.
And what's your name, sir?
David Ferrera.
All right, thank you.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Division. This is case number 24-682, a violation of the Citrus County Land Development Code, Section 9110, signs. The address is 1 Beverly Hills Boulevard, Beverly Hills, Florida. The property owner is David Fiera. I have a good service via signed certified mail return receipt, and I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on April 10th, 2024. Photo taken on May 7th, 2024 at my corrective action inspection. And photos taken on my final inspection, June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on May 11th, 2024.
So, sir, what I'd like to ask you to do is look at these documents and let me know if you have any objection to them being evidence in this hearing, and take your time.
No.
Okay. And, sir, are you contesting whether or not a violation has occurred on the property?
Yeah.
Okay.
On 5 different points that I've received for the rejection of the permit.
Got it. And just for the record, are there any members of the public who are going to want to be heard on this? Okay, thank you. Okay. Without objection, what's been proposed as Exhibits A and B are admitted as evidence. Please proceed.
On April 10th, I conducted my initial inspection and observed the thrift store sign located on the Beverly Hills identification, brick wall, and thrift store building, and other signs. As of my final inspection on June 18th, 2024, the signs remain. The owner is aware of the violation, and he's submitted for permits.
Okay. Do you know what the status is of the permits?
The permit has not yet been issued. I have expert witness Joanna Coutu.
All right.
Good morning.
Morning.
Yes, there is a signed permit in-house. It was submitted on May 12th, denied on May 23rd, and again on June 10th. The actual site plan application does not have all the signs that are on site. There are quite a few signs on site, some wall signs, some banners, and two freestanding, which they can have one. So it's not hard to fix this. He can take down the excessive signs, and we can permit the others.
All right, I just want to make sure I understand. So what the county's testimony is there's a lot of signs at issue here.
Yes.
And that even if he's successful in obtaining a permit for signs, he's not going to be able to keep all of the signs that he currently has.
Correct. It exceeds the allowable square footage. He's got too many.
And let's see, could you direct me to the part of the code section in 9290 where it talks about the square footage?
Can I approach? I don't have it memorized.
Okay.
I'm sorry.
If I ever memorize this code, it's kind of.
It's not
It's not gonna be
9290.
92.
Oh, it's,
That's what it says in the agenda, but it's not.
okay, I was wondering about that as well. Do you know what code section
Should
it
be on
is?
the NOV.
On the
It's in the notice of violation?
Yes, sir.
Well, that's
It's
good.
9110.
9110. I just want to know and understand fully what the law is before turning to you.
That's why I'm here too.
Yeah. Okay. All signs except signs listed shall require a sign permit. Mm-hmm. Number of signs, okay, all right, thank you. All right, so several relevant code sections have been pointed out to me. And I'm just gonna take a moment to look through them. I mean, there's even a code section on the distance between signs in section 9231. Section 9210 talks about signs exempt from permitting. There's a lot of those. Okay, so let me look at the evidence here. All right, so I see a sign on the brick wall. I see a sign on the other side.
If I could interject, the one on the opposite side of the brick wall has been removed.
Okay,
That was not on the permit, and that wasn't there when I started the permit process. That was something they put up.
gotcha. All right, so I see one on the building that says thrift. Is that still there?
Yes, it is.
Okay.
It's a tarp tied tightly to the building, which seems to be the standard practice in this county. The path across the street has 2 tarps tied to their fence that are not wind-prone. Basically, every billboard in the county in this, that's solid has a tarp taped to a billboard. Ruby Tuesdays, Applebee's, Chili's all use tarps wrapped around signs that are not wind-prone.
Has the county told you that those are not allowed?
Or they told me I can report it, but that's not what I'm about. I'm not gonna go around. We found over 700 different violations of the same ones that we're being cited for in this county.
Well, that's why I'm trying to narrow the issues here, because it's very common at hearings that someone says, well, look at somebody else's property, but that's not a defense to whether the violation has occurred on your
Well,
property.
that's why we can't understand why it's a violation. Everything that it states in the code
Yeah.
says that banners can't be used if they are subject to wind. None of our banners are subject to wind. The one on the peak side building has a wooden frame around it, holding it. That was part of the permit process.
Okay.
The banner that is tied tightly underneath the 14-foot overhang against the stone wall on the building is the only sign on that side of the building.
Well,
And it's tied tightly.
let's start by talking about what the signs are. So tell me, what are the signs at issue here?
For Living Waters Thrift Store.
Yep. And how many signs total are we talking about?
I asked for permits for 6 signs.
Okay, so You've
Right now,
appli-
there are 8 and 2 have been removed or are being removed.
So let's start, just,
Yes.
let's slow down. So originally, there were 8 signs, you're
Yes.
saying, okay. And 2 were removed.
Yes.
What were those 2 that were removed?
The one on the inside cove of the wall, number one, it wasn't attractive, and number two, I hadn't given him permission to put that there.
Are you the landlord?
Yes, I am.
Okay, so this is a tenant we're talking about.
Yes, this is a religious organization, thrift store, and church.
Fair enough. And so we're talking about the 2 that were removed. One was on the inside of a wall?
Yes.
And then what was the other one?
There was another loose one that was sitting beside the building, and that was actually, it only been there about a week before I saw it.
Okay. Ms. Becker, are you aware that both of those have been removed, or do you confirm that?
I can't confirm, because when I was there yesterday, they were still there, but I believe,
Excuse me for 1 second.
Okay, sure. Those, but you are aware of the 2 signs he's talking about
Yes, I
by
am.
location?
yes, I am.
And as far as you're aware, based
As-
on your inspection yesterday, they were still there?
Affirmative.
Mr. Freer, were those removed yesterday?
Yes,
Okay.
I returned from Utah. I had no understanding that this had been rejected again. I had received no email, no notification.
No, it's a no-fault issue. I guess I'm just wondering.
But I'm just
um,
saying, I didn't know about any of this until yesterday when I arrived here
Yeah.
to ask the status of the permit.
All right, I'm just trying to drill down into the
Yeah.
facts. So it's your testimony that those 2 signs are removed?
Yes,
And is it, Ms. Becker, if that was true, are those 2 of the ones that you can't get permits for? Or, Ms. Katu?
Yeah, correct. Those are 2 of the problems. Just to clarify, I think the argument is they're banners, so they're not allowed. Nobody said that. It's square footage of the signs, and you add them up.
I'm just not there yet.
I know. I heard his argument. I thought I'd warded off at the pass, but I
I'm very
apologize.
slow sometimes,
No, you're
so
fine.
I just need
So
to work.
those 2, removing those 2 helps quite a bit. We
Okay.
couldn't have got permits for those 2.
So here's my question then. My question is, of the remaining 6, let's assume it's truthful testimony, he swore an oath. Are they able to obtain a permit for the remaining 6?
The square footage seems to be too high still, and one of them.
That's your guess. You don't know for
My
sure,
best
but-
guess, yes.
okay.
And there's one that's on a trailer parked in the right of way. That one absolutely cannot be permitted. So I don't know if that
It's on
was
a
included
trailer
in the
in a
6.
right-of-way.
Right.
I would like to speak on the trailer and on the truck that was brought up in the rejection. The trailer is a delivery and pickup trailer. It's registered. I have proof of that right here. It is moved nearly daily. It's not in the right-of-way of traffic. It's parked on one side of the parking lot or the other. Yes, it does have a sign on it because just like Habitat for Humanity or any other service truck, their advertisement is on the side of their vehicle that they use for their business.
Yeah, so, I mean, I'm not ruling one way or the other on this, but well, let me ask the county. So if it's something that's not permanently parked there and it's something that moves, isn't that?
Right. There's a section of the code where you can actually do that with,
Yeah.
with advertising, and there's a time limit. We've cited it overnight. It's been there repeatedly overnight. It exceeds the time limit.
Do you know where that
Yeah.
time limit is?
Now, they use a common parking space a lot of time
Mr.
at
Ferrer, if you
night.
don't mind, I do want to hear from you. It's just,
Okay.
I need to understand what
Okay.
they're even
Okay.
saying. Okay, all right, thanks. Let me just take a look at this. All right, so I've been directed to section 9220, which talks about signs that are prohibited unless authorized by a variance. And I'm looking at subsection I. Just give me a moment. Wow. Okay, so I guess, Mr. Freire, this is interesting. Is the sign, is that vehicle used by the business?
Daily or near daily. Whenever they have a large pickup, they hook it up to their van, which also has a sign on it.
How is it used by the business?
They go to pick up donations. Large furniture, large items, small
That
items.
would make sense, okay.
Yes.
I mean, does that help the county understand why that's there?
If it was truly a loading vehicle, it would be expected in a parking space. It wouldn't be expected to be there every single time I go by.
Does
It's
the
in-
county have any testimony that this is a vehicle not used in the conduct of the business? I mean, I know lots of thrift shops and they need some kind of way to move
Excuse
furniture.
me, can I enter
No, not
pictures
yet,
of
no,
the trailer?
no.
I don't know. Have you seen it every time you've been there? I've seen it every time. It's in the right of way. That's the problem. I mean, you heard him say it's out of the vehicle lanes. It is. It's not in the pavement, but it is in the right of way. It's parked in the right of way. Can't possibly permit it. If he moved it interior and said it's part of the use of the business, then perhaps we could look at that
All
way.
right, so I'm gonna find that it does not violate section 9220 subsection I, because the only testimony I have is that it is used in the conduct of the business, and that makes common sense to me. But I think what the county's saying is, there's still subsection H, which is, it's prohibited when signs are on public property, including rights of way, other than signs erected by a public authority for public purposes. So he's testified it's not in the right of way. I just want to understand where the thing
Right,
is.
actually, his wording was it's not in the vehicle lanes, which is true. It's not in the
Okay.
pavement.
Okay, I thought he said
It's in a
right away.
parking space. When we
It's in a
had it in a
parking
parking
space.
space by the road, we were told we can't have it
Well,
there.
just hold on a second. So it's in a parking space with
Yes.
lines?
Yes.
The trailer?
Yes,
It's not an approved parking space. It's in the right of way.
it's either backed up to the
All
building
right, so we have
or
a
it's
dispute of
backed up to the
facts, so
curb.
let me look at the photos.
It is never in the right of way, because we also have a curb on the right side of the parking lot, and that's where it is parked against when it's not being used, because we were told that it couldn't be against the road,
Ms.
even though
Becker,
that's
have
my
you-
parking space.
Do you have any photos of where the,
The 6/18
Currently, I can show
I'm sorry,
you.
hold on, I'm sorry, I'm almost there. I just need to understand their case.
Okay, you asked me for photos, I was just.
I will get to
Okay.
your photos for sure. Can you help me?
This is it.
Okay, so I'm now looking at page 8 of 8. So, Ms. Becker, I mean, I'll give you the microphone here. I do see the trailer. Do you know? I guess you can take it. Why don't you take it, and we'll talk about it. Is that in the right of way?
No, that's not the right one. We're talking about right here, the one he has here.
Please note the curb behind the trailer.
I do, I see it. That's why I'm asking.
Okay, that's not the right picture. I apologize. I'll find one.
The picture I have
I
was
do want to,
taken
now I want to
yesterday.
see your photos. Could you
Okay,
bring
the
it back?
picture I took-
Actually, first, can you show it to the county? Not me.
This picture was taken yesterday. They were unloading from this and from the.
Mr. Ferrer, please go to the microphone, and when you're at the microphone, put everything you're saying on the record. This is just to preserve your rights and when you're speaking to Ms.
Okay,
Becker.
the trailer is showed parked against the curb separating the two properties. It is backed up next to the van. They're unloading material that they got as donation the day before. And then once that is completely unloaded, it'll be moved back to its parking space on the opposite side of the building.
Just, if you wouldn't mind, show your photos to Ms. Becker.
And that is the
I
license
would like
plate to
to
show
know
that
from
it
the.
is legally registered.
I'm sorry, hold on, sir. I would like to know from the county if the county has any objection to these photos being evidence in this case.
That's not where it's usually parked.
What I will ask is, did you take these photos?
I did yesterday.
Okay, all right. Does the county have an objection to these photos being evidence?
That's not where it has been observed to be. That location would be okay.
Okay.
Presuming it's in the,
Okay.
Can I ask a question?
No,
We are going-
no,
No.
not yet. I promise, you will get a chance, just let me run the
Okay.
hearing.
right. So if it stays in that location,
I'm sorry, Ms. Katu. Let me
Yeah, you're
just,
fine.
what I'm gonna do is I'm going to admit your photos as evidence, Mr. Ferreira, and I am going to just take a look at them. We'll admit them as, just Exhibit D, or Exhibit C, I'm sorry. And what I'm gonna do is I'm gonna compare them to the county's photos that are in evidence. Ms. Katu? Would you, you wanted to, I don't want to,
No, you're fine.
I am struggling to understand the
That's
photos.
fine. I do have a picture, but if he's moved it to that site, fine. That
The
particular,
photos from
that
you
particular
and
sign-
him are consistent that there is no violation based on this sign.
on that particular one,
Correct.
yes, you're correct.
So now we're down to 5 signs, I think, that I want to talk to you about.
Yeah, I don't know how many, but yeah, okay.
Well,
Every,
that's
every
important for
wall,
this.
every wall sign,
That's important for this hearing. So we established originally that there were about 8, I think. 2, according to his testimony, are no longer at issue. I am making a ruling that the 5th, that this one on the trailer, I may find that there was a violation, but there isn't today, right?
yes.
Okay. Now, in terms of the other 5, I need to drill down.
Agreed.
are-
It's not the number, it's the size,
I
the
get
square
it.
footage.
We're not
Okay.
there. So
Okay.
of those 5, I need to figure out, do they constitute a violation or can he get a permit for them, even if they are a violation? And that is what the county needs to prove.
Okay, so the items submitted in the permit exceed the allowable square footage. So if he takes the permit and pulls off a couple and meets the square footage, then yes, he can.
Can I ask a question against that?
You're going to be able to ask all
Okay.
your questions. I just need to understand first. So you're saying regardless of the number, it exceeds the square footage.
Correct.
What is the number of signs he has asked for?
Well, his permit was for, I think, 8 originally,
Okay.
but now, and it still is.
He's,
So-
all right, but he's
so he'll
peeled
need to
off 2.
modify.
We've taken off 2.
Right.
I assume, Mr. Ferreira, that since you've removed 2, you're not going to seek a permit for those 2
No.
anymore, correct?
No, those were not ones that I had given permission to put up because they were unsightly.
All right. Do you know if it would still exceed the square footage? once
I
those
do,
2
based on the wall signs that are there, just counting in my head, it does still exceed the square footage. It's 1.5 times the width of the building,
Mm-hmm.
and he's definitely exceeding that, but he can, pick and choose and probably get there.
Now,
Can I ask a question?
you can
Okay.
cross-examine. So now I'm
Okay,
done
now,
with my.
there are 2
Hold on,
diff-
Ms. Ferreira, just hold on.
Okay,
I'm done with my examination of the county witnesses.
Okay.
My questions I have. Because they presented evidence, I now give you the opportunity to cross-examine them if you wish.
okay. Number 1 on the question is, we have 2 separate properties, side by side, 2 separate entities. We have a church, a financial foundation to assist people coming out of prison, and the receiving garage for a thrift shop on one side of the property line, which is 2 North Melbourne. And we have 1 Beverly Hills Boulevard, which is the actual thrift shop, which currently has 3 signs. And there are 3 signs remaining on the other building as well. So
So what you're,
is the square footage like on an entire, both properties? I pay taxes on both, I pay utilities on both. Are they considered one unit?
It's
Because I'd
ba-
like to get a break
Can
on
I
my
answer that?
taxes.
it's a good question.
It's based on the building width. So for the one property with the one building, it's gonna be that width. For the other property with the other building, it's gonna be that building width.
I'm positive we do not exceed the square footage of signs allowed by the county on either
So,
building.
Mr. Ferrer, let me ask you this then. I think you've raised an interesting issue. So you're telling me that in these photos, we're talking about 2 different buildings?
Yes. Yeah, on the permit, it does state 2 North Melbourne.
We did not cite
They seem to be leaving that out.
Okay, but you're telling me that there's 3 signs on one and 3 on the other?
Yes. I do have picture evidence of all of those signs.
Did not. The notice of violation is for 1 Beverly Hills Boulevard, for
Which-
clarification.
Which would be how many signs?
That's the.
But they are combining.
Hold on.
in the
That
notification.
may be
The
true. I
sign
don't-
permit was for that particular site. If he was trying to include the other one, we can take a look at that, but that wasn't part of the citation or part of the permit at this time. He can, like I said, I think we can get there. He might have to cut a sign or 2 out, but we can get there.
I was under the impression, based on all the testimony from the county, that this was all one one site, so if
It-
it's
it is.
actually two.
It is one site. He's saying he owns the other and is using it as well. That's not what we're looking at and wasn't part of the
But I
permit.
think you're telling me that only one has been cited.
Yes.
Can I ask Ms.
I'm
Becker
sorry.
a question? The photos you submitted today, of the signs that you submitted today, are they all located on 1 Beverly Hills Boulevard?
Affirmative.
Are any of them located on the second address that he's mentioned this morning?
No.
Then why have we been talking about six? Oh, okay, so that's his, so from your perspective, and what the county's testimony has been, is that actually the only signs we're talking about are on 1 Beverly Hills Boulevard, right? And that the number of signs that are there exceeds the square footage that's allowed for that site. And
There-
we're not talking about 8 signs, we're not talking about 6 signs, we're only talking about 3 or 4.
Well, there was 8, he took away 2, so would that still, I'd have
But
to go
only
back.
on one, only on,
On 1 Beverly Hills Boulevard.
oh, so
I'm
all
only-
8 were on
I'm
Beverly Hills Boulevard.
There was 8 on 1 Beverly Hills Boulevard.
Okay. Is that not, you don't think so?
I was asked to comply for both buildings. Amy told me exact words were, you need to get permits for both buildings so we don't have a problem.
Well, maybe you do,
The
but
5 points that they told me that they were rejecting my permit, over half of it is for 2 North Melbourne, which is why I'm here, because I am arguing,
is that from the county or is that
this
something you?
this was printed from the county.
Okay, I'd like to see it. Could you show this to the county?
That's what I was handed at the
You know-
desk yesterday. And then, can I show you these signs?
Hold on, not yet. Let's go one at a time.
So I think to try to clear up and get on the same page, we're going to ask for a continuance.
Okay, do you guys have any objection to this
I do.
document being evidence?
I don't have any objection to that being evidence, but I do have an objection to this being continuous.
Okay.
This needs to end today.
All right, let me take a look at this. Does the county have an objection to this document being evidence?
If it applies to the second property, it's irrelevant. The information for today's hearing is, I'm sorry, she should be talking.
Letting her speak.
You'll incorporate
I'm
Ms. Antrim's
incorporating what
comments?
Ms. Antrim
Um,
just stated. If it does, unfortunately, there's no identifying information on that document. It does have within it, it looks like a few paragraphs that might have been pulled out of something from the county, but there's nothing that actually states what this is in reference to. So if it is in regards to the second property he's mentioned, it's not relevant for today since the citation and everything for today is only for 1 Beverly Hills.
All right, let me take a look. Ms. Becker, where's the vehicle with where's the trailer located?
The trailer's located, well, when I was there yesterday, it was at 1 Beverly Hills Boulevard.
Yeah, I mean, but in your photos that you took, that you showed
That's
me.
1 Beverly Hills Boulevard.
Okay. Well, definitely part of this applies to that then. I'll admit it as Exhibit D. Okay, there's a lot of issues here. Let me look at these photos again. Ms. Becker, can you show me which one is 1 Beverly Hills Boulevard and which one is the other property on Exhibit A? If it shows it, I don't know. And I'll hold it up for Mr. Ferrer to see what we're looking at.
also, David, do you mind if I show them this?
That's fine.
Okay.
So basically, this is 1 Beverly Hills Boulevard,
Mm-hmm.
and this is 2
Ah,
North
okay,
Boulevard.
okay.
So the signs.
That makes a lot more
By the
sense.
way. Okay. So the signs, when I was there yesterday, which you already said 2 are gone, there was a sign on this wall, there was a sign behind here, there's a sign here, there's a sign here.
Do you have any objection to this being evidence?
No.
All right, we'll admit this as Exhibit E.
And then there's a sign on this, and there's 2
Let-
signs.
You'll have to start from the beginning again. I wasn't in it. So showing me on this site plan, where were the signs that,
And David, just let me know if I'm incorrect. So yesterday, so there's one here, and then
on the
there's,
Beverly Hills wall?
correct,
Yeah.
the Beverly Hills brick
Can
identification
I
wall.
clarify something on the Beverly Hills wall real quick? I own the Beverly Hills wall.
Okay,
That's on my deed. I pay taxes for the property underneath it. And
Okay.
part
Yes,
of
yes,
the
great.
issue is they're telling me I cannot have a sign.
let me understand
Yeah.
what they're saying. So
Yeah.
you're pointing out the signs to me. Show me the signs.
There's one here,
Mhm.
there's one back here, which he removed.
So there was one that wasn't on the wall,
No, there's one
I
on the
spoke to
wall,
Wayne
On the
just
front of the
as
wall.
they
there's one
removed
on the
this
wall,
one.
and then a
And then
second
there's-
one right here.
Yeah.
right.
And the
which he's
second one was
removing.
removed.
Yes,
Okay,
Okay.
yeah.
And then there's one right here, there's a banner on this structure,
okay,
and then there's a banner here on
Okay.
this side,
okay,
and then there's a banner here on this
okay.
side,
I've seen that.
and then there's 2 right here.
Yep.
Okay, am I correct?
And there was one here on a trailer that was parked.
Correct, which Joanna said was fine.
Yeah, when we had the trailer over here, I was notified by Amy that I wasn't allowed to have it there, even
Mhm.
though it's a parking space.
Mhm.
I'm gonna assume that it is a parking space, and that's where it's gonna go when it's not in use from now on. Because that is my property. Inside that cement curb is my property.
Where's your
This
ingress
is-
egress?
This is the right-of-way. This is a GIS map, so the
I have a
yellow is the
survey.
right-of-way.
Hold
Never
on,
been a
I'm just
survey.
asking where your ingress egress is on this exhibit.
Here, every
And there's-
place
this
in-
isn't an
this is a
ingress
dead-end
egress?
Parking lot, yes,
This is not ingress egress?
no.
Okay,
That's a
these are
dead-end
just parking spots?
Correct.
Okay. The trailer looks big, though, to park there.
It's only a 12-foot trailer.
Oh, okay.
It doesn't even take up a full parking space.
Okay.
So it's fine.
So we agree that if it's in a parking space, that's not a right-of-way.
Joanna, I'm just confirming, we agree it's in a parking
No, we do not.
Really?
Not agree.
Normally, what you're saying, yes,
Mhm.
but that particular isn't a space. I know it looks like a space, but it's actually it's got part in the right of way. It's not a parking space that we recognize.
There is no right of way there because there was no way to get out of it.
I mean, there's a curb, there's landscaping,
okay,
there's
Your Honor,
land,
at
no,
this
no,
point-
no, there's landscaping, but I'll let you speak, but just let me finish. Honestly, there's landscaping between the parking and the road. So how is that right of way?
You can have landscaping in the right of way. I really just.
Yes, you're
I
right
really-
about that,
Really
but-
just want them to get a permit, and honestly, I can go out there and meet and go over every single one that's out there, and we can try
You know
to
what,
straighten
I'm gonna
it.
take a minute to think about this, because I don't.
I just want them to have a permit, and we can go
Ms.
over that.
Katu, I take this seriously.
Absolutely.
Well, you were laughing.
No,
And
I was
look,
not.
About the right of way, and look,
My biggest issue was excessive.
not all of us are
I'm not
professional-
laughing in any way. I apologize if that came across, that was not.
You mean when I asked and you smirked and smiled and said,
No.
you can have landscaping in a right
It
of way?
wasn't, I conveyed
Ms.
it
Katu,
correctly.
listen, I agree with you, all right?
Okay.
I'm not trying to debate that you know more than me about this either. But, you know, I'm trying to understand how that part of the parking lot would be Ms. Harrison?
If I could see the photograph to see which portion of
Yeah.
the parking lot. Because, again, this is other,
This is the GIS map.
okay. Which portion are we discussing?
So this is 1 Beverly Hills Boulevard, this is 2 North Boulevard.
And this is the ingress egress?
This is just, I don't know
No,
enough.
it all has to be on the record.
Okay.
Please go back. Go back.
When he was
Mr.
just,
Ferrera, can you step back
Yeah,
so you can get
please go back.
recorded on the record,
Thank
please,
you.
sir?
Ms. Becker,
Thank you.
when, unfortunately, I wasn't over there with the special master when everybody was pointing things out. Where did Mr. Ferrera indicate on this map was ingress egress when the special master asked? Was it here?
Here, it's right here.
Right here.
This is where the trailer.
That's not what I asked. Where did he indicate ingress and egress was when the special master, if you don't remember,
Okay,
I have no
I
problem.
do remember. It's where the road is, where
This
yes,
side?
that's where they indicated ingress
Okay.
egress
That is the
was.
only driveway.
Okay, so this is ingress egress. Where on here was the trailer parked and we have a question about? So over here,
And that's what I'm just trying to understand, because he indicated an intention to put the trailer back, even though the undisputed testimony is that where it is fine, which is confusing to me. I don't know why you'd want to move it when where it is perfectly fine, but
okay, so my question, to get clarity of everything, is over here, where it was just testified, where it's stored, where it was parked in all of y'all's photographs?
Yeah.
Is this where it was when, in y'all's photographs?
no.
No,
It was parked against the curb separating the two buildings.
It was parked where?
There's a curb right here.
Uh-huh.
It was parked right here.
Okay, so for testimony today, when it was parked over here, everybody said, not a violation, it's good.
Correct.
Now we're saying we want to move it back over
That's what I'm
here.
asking about.
Okay,
yes.
and that's where we got, okay, sorry.
yes.
I'm so sorry. Okay, so,
Mr. Ferreira, please go back to the microphone.
okay,
Ms. Becker, could you also go back to the microphone?
so I unfortunately, this is kind of zoomed out, I can't quite see it. Is, from the county's perspective, whether Ms. Becker or Ms. Katu answers, I'm not sure who, is this entire parking lot, all the way over to here, is all of this actually permitted, supposed to be here? Parking lot.
Is the parking lot supposed to be there?
Sometimes people expand parking lots without getting county permission into
Okay.
right-of-ways.
Okay.
So I'm sorry, I'm trying to get back
No,
around to your
okay,
original
that's
question.
Right, and I'm sorry if I misspoke. Yes, that was the problem, is it does appear to be that parking space was not one I could find on previous permits.
Okay, so even though the parking space is at the ingress egress, as well as to this portion over here along 491, the portion along 491, we cannot find a county permit for?
Correct, that's why I was not considering it a parking space.
Okay, so even though it has lines and appears to be a parking lot, did the county records reflect that this unpermitted portion of parking spaces may be in the current right-of-way?
That's what, part of the trailer was. It stuck out outside of the pavement into the grass area that appears to be right of way.
Okay, so that's how somebody could be parking in a parking area and still be in the right-of-way.
Correct.
So if he was parking somewhere where it didn't extend into the right-of-way, would he be allowed to keep the sign on the trailer?
As he's described it, yes, it was a vehicle for the business.
Okay, so at this point, we have no objection as long as he doesn't extend the parking into the right-of-way, no matter where it's parked. in the
Yeah, that's what I was getting at. I
Okay.
mean, that makes sense.
Okay.
Okay.
Then we have, obviously, except for the trailer, all the other signs would require permits. He's indicated he's taken a couple of them down, and now he's excluding the trailer one, so he's down from 8 to 5, because if, again, I couldn't see what they were pointing out to you. It appeared that Ms. Becker and Mr. Ferrer agreed that the signs that Ms. Becker indicated were all on 1 Beverly Hills. Was I correct in what I heard over there?
I came to this hearing
No,
this morning.
please answer my question. I'm so sorry, sir.
I'm-
I'm just
I'm-
trying to
Ms.
get it.
Harrison,
I'm
also, I'll
trying-
handle the
I'm trying to understand the question.
chastising. So
No,
I'll
I'm
handle the
so-
chastising.
Okay, I'm so sorry.
But do you understand what her question is?
I'm trying to understand the question in that I thought I was coming to this hearing because my permit was rejected and I was in violation.
So that's part of it, all right? The reason you're at this hearing is that there's still a violation on the property, okay? One way you can get out of the violation is by obtaining a permit for the signs that you have on there.
They
Because
rejected
your
the permit.
permit was rejected, you have not abated the violation so far, all right? But we're actually much closer to a resolution than I think some people may believe. In other words, the question, and what I'm trying to figure out for the purposes of resolving this hearing, is whether or not, number one, a violation still exists on the property. And if a violation still exists on the property, how much time do you need to get the permit, right? Because it sounds like, and I don't disbelieve the county, that the signs you still have exceed the amount that is allowed at 1 Beverly Hills Boulevard pursuant to the Land Development Code. Does that all make sense?
When I totaled the entire square footage of all of the banners, if you total both buildings, yes, it exceeds square footage, but just one or either does not.
All right, Ms. Harrison?
So, again, I could not see what y'all were looking at. It sounds like we started at 8.
By the way, that's true for a lot of people. That's true for witnesses. It's true for others. It's part of the problem with exhibits that aren't on the screen. If it's on the screen, we'll all be able to see it.
We started at 8. He's admitted he's removed 2. We're removing the trailer, so he's down to 5. It appears that all of them are on the 1 Beverly Hills property, so the 2 North Melbourne is not at issue. So he would need to reapply for the lesser signs, and he may qualify. He may get the same thing back where he's,
Right.
but it sounds like because he owns 2 businesses, I haven't heard anybody say anything about a garage, except I think he mentioned it over here on North Melbourne, and his exhibit mentions something about a garage. So I think he, when he's applying, might need to be a lot more clearer, and it might help him in the future.
Let me know if you have an objection to what I'm about to say. So, Mr. Ferreira, here's the issue. Whether or not your signs that you currently have on the property qualify for the permit, you're gonna have to change the application, right? Because you've asked for 8, and you have admitted you've taken off a few. So like the application's not current, all right? It may be that when you resubmit the application, the signs that you're requesting the permit for will make the violation go away.
Okay.
It may be that you still have too many signs under square footage, okay? But no matter what, you do have to have a permit for even the signs that we agree,
Okay.
right?
I understand.
Hold on. So I want to tell you where I'm going with this. I am going to find that there is a violation because you don't have a permit yet, okay? I'm not making a finding about the square footage issue, because that's not, really, you just have to get a permit, all right? Now, if they refuse to issue a permit based on something that you think is legal, then you're gonna have other remedies that you have to look at. But for the purposes of this hearing, I have to find that there's a violation because there is no permit. Does that make sense?
Can I bring up one more issue that's within this violation, which we have not been able to find an ordinance for, neither have they, it's just opinion. Can I enter this picture into evidence?
Tell me what it is
This is a
exactly.
picture of what they call the Beverly Hills Welcome Wall, which is within my deed by survey. I maintain the wall, I paint the wall, I fix the cracks, I take care of the landscaping, I mow the lawn in front of it. I have a sign on the far end of a 110-foot separating wall, a wall that I own, and they're telling me that I'm not allowed to have 2 signs on a wall. One is a painting that says Beverly Hills. The other one is the sign for the thrift store, because it is the only visible from that corner sign on the entire lot. And I'm being told by opinion, not by ordinance, that I can't have it there.
I think I did see an ordinance that addresses this. I don't think you're being, I don't know, but I don't think you're being cited for this specifically, but let me look.
In the rejection, I was told that I was not allowed to have two signs on that wall.
Okay, so
Without a statement of ordinance or reason other than opinion.
are you talking about number 1 on Exhibit D?
Yeah, I don't have that in
Or
front of me
E?
any longer.
You,
but-
you said only one freestanding sign is allowed per
No,
parcel?
that's for the other signs, and that's both placed, and that's actually on the other property. This
Oh,
was-
I see. Only one sign can be on the wall that has Beverly Hills on it. Please remove the thrift store sign or the Beverly Hills sign.
Yes. This is a 110-foot-long wall that's 7 feet tall. The opposite side of the road is the same wall that's owned by the Path homeless shelter. And personally, they'd like to remove it, and I'd like to remove the wall because they have things go on behind that wall. We spoke to Community Betterment in Beverly Hills, and they were adamantly opposed to us removing it, but they had no problem with us having our sign there.
This is actually relevant for what we're here for today. It would appear as though 9250 applies regarding on-site signs. And they did mention that earlier on in the document that you provided. And then Section 9238 talks about number of signs and says that for the purpose of determining the number of signs, a sign shall be construed to be a single display surface, effect, or device containing elements organized, related, and composed to form a single unit. In cases where material is displayed in a random or unconnected manner, or where there is a reasonable doubt as to the intended relationship of such components, each unrelated component or element shall be considered to be a single sign. So I think what they're saying is, look, under 9250, you're allowed one on-site sign, but under 9238, you actually have two there. And that's a violation.
But now the Beverly Hills sign is just a painting on the wall. All over the county
So
there
we
are,
look
and
for the
I know-
definition of
And I
a
know that they're permitted, that there are murals and welcomes on the
I
sides
think you're
of
allowed to get a
buildings.
variance under the code, but here, it talks about what a sign is, and it's very broad, what constitutes a sign. So I do understand if that's the case, and it would be subject to the, I'm not saying that the county's wrong about that.
I wish to appeal that part.
Well, here's what I'm gonna do. What's the county's recommendation?
The Citrus County Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation, and we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, so what I'm gonna do is I am gonna find that there's a violation under the notice of violation that you were given, section 9110, permit required, meaning that you have to obtain a permit for the signs that you have on
I
the
can
property.
only apply, I can't make them do anything.
Well, look, I always encourage folks to retain legal counsel, all right, to discuss your options, but I am finding a violation under this section, And specifically, I'll make reference to, you have to get a permit for these signs. Now,
Okay.
when you go through this process, what you work out with the county, that may be a separate issue. I am gonna grant you 30 days to do it, and if it's not brought into compliance as ordered, then $50 per day.
Okay.
Okay,
Thank you.
Your Honor, I still have your Exhibit E. Do you want me to write Exhibit E on it or just return it to you?
Just return it. I mean, the
Okay.
Sparrows, what do you handle this?
Yes.
Okay. This will be Exhibit E on this?
I will.
Yeah, all right.
Next case on the day's agenda, Pete Thomas Jr., case number 2024-718, Code Officer Brandon Norman, page 31 of your agenda.
Page 30.
Good morning,
Morning.
and thank you for your patience. Is there anyone from the public who's going to want to be heard on this case? Okay, I don't see any response.
Ma'am, I'm gonna have to call another case. Ma'am, I'm gonna have to call another case, I apologize.
I'm sorry, ma'am. I think you're pretty close up there in line, but it sounds like they want to present another one, so we're going to go ahead and do that first.
Okay.
I'm sorry. Hopefully, they don't all take as long as the first one, but everyone has a right to be heard.
Next case, Carl and Rihanna Dean, case number 2024-558, Code Officer Julie Wilkinson, page 6 of your agenda. Expert on the case, Joanna Katu. Did she just go out?
Good morning.
Morning.
This has never happened in
No,
my
I
years.
apologize.
No, that's okay.
That's fine, I ain't no hurry, I can sit back down.
I'm sorry, sir.
I'll call another case.
Yeah, we're going to call another case.
DR Horton Incorporated, case number 2024-507, Licensing Compliance Officer Timothy Williams, case, page 7 of your agenda, expert of the case, Building Director Samuel Acosta.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Morning. Timothy Williams, Citrus County License Compliance Officer. This is case number CE 2024-00507. Chapter 18, Article 1, Section 18-A, obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinance. Address is 481 West Rexford Drive, Beverly Hills, Florida. Property owner, DR Horton, Inc. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 15th, 2024. Corrective action inspection photos on April 25th of 24, and the final inspection photos on June 18th of 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt indicating good service.
All right. First, let me ask, is there anyone from the public who wants to be heard on this case? Let me ask you, Mr. Williams, have you had any contact with DR Horton? It's when I saw them on the list, I was very surprised. I know they're lawyers. They're good lawyers. I'm just surprised to see them.
I had a couple conversations with the superintendent, and then it went up the chain to their bosses.
Okay. And is there any response at all to this from them?
They are in submitting a permit, but it's involved case with a retaining wall.
Okay. Well, I don't hear any objection. I don't know if the county attorneys want to look at the exhibits. All right, then without objection, what's been proposed as exhibits A and B are admitted as evidence, and I'd like to see them.
All right.
Thanks. And go ahead whenever you're ready.
All right. On March 15, 2024, an inspection was conducted at 481 West Rexford Drive in Beverly Hills, and photos were taken regarding the installation of a retaining wall without an issued permit. During my inspection and research, I observed the retaining wall and found no permit issued for that wall. A notice of violation was issued on March 25th of 24 for an after-the-fact permit. At my corrective action inspection on April 25th and final inspection on June 18th of 24, the property remains the same and without an issued permit.
Mr. Acosta, do you have any testimony that you want to offer?
Other than the permit would be required.
Yeah.
Now, yeah.
Yeah, very surprising. I mean, would this normally be obtained at the same time that I assume they have a building permit for the home?
Yes, there were two permits. This is a retaining wall between elevations of land,
Mm-hmm.
and it could possibly be in the right-of-way or the easement
Oh.
and drainage issues.
So is there a possibility a permit wouldn't be issued for this and that they'd have to take it down?
Maybe.
Is there an implication for the house if they have to take it down?
I do not know that, no, sir. Drainage, I think it's in engineering right now.
What's the county's recommendation?
Citrus County Code of Compliance Division respectfully requests the special master assess a fine of $50 per day with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. We would also like the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order for a re-inspection.
Have they filed an application for this at all? They have?
Yes.
Okay. All right, then, do you know how long that review process takes? On average? No?
It's gonna be a good month or so.
Oh.
Before it, I would think.
Okay.
It's,
You would
Yeah,
think,
From Florida building code perspective, it's not much of a review, but I think the issues getting to the engineering and that type of stuff.
okay, then I'll find that the property's in violation, grant 45 days from today to abate the violation. If it's not brought into compliance as ordered, $50 a day. Thank you.
Next case on the day's agenda, Carl Dean and Raina Dean, case number 2024-558. Code Officer Julie Wilkinson, page 6 of your agenda. Expert on the case, Joanna Katu.
Mr. Dean? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please state your name.
Carl Dean.
Thank you.
Good morning, Mr. Dean.
Hi.
Good morning again.
Good morning. Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400558. Land Development Section, Code Section 3102E, Special Requirements for All Accessory Uses. The address is 7180 West Matador Lane in Homosassa. The property owner is Carl and Renee Dean. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on March 22nd, 2024. Photos taken during a corrective action inspection on May 1st, 2024. And photos of my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you two things. Number
Yes, sir.
one, number one is to look through these documents and let me know if you have any objection to them being evidence. Number two is, are you contesting whether or not a violation is on the property?
Absolutely not.
Okay. How much time do you need to fix the violation?
Is 60 days too much or 30?
Tell
My
me.
son lives there.
So let's jump ahead, Ms. Wilkinson. What is the actual, tell me about the violation.
So the violation is that there's a Connex container on the property, and you can no longer get permits to have those, so the Connex needs to be removed.
How big is that?
Oh, I,
34-foot long.
34 foot long.
Huge.
Okay. So you can't just hook it up to your Ram 1500 and bring it out of there. Okay. Is there a health, safety, sanitary concern?
no.
Okay. 60 days is okay by me if you concede the violation.
Yep.
What's
My son and his wife, because they live in my house.
Okay,
and,
fair enough.
They keep saying, we're taking care of it. They told me not to come today. They told me you said everything's clear.
Oh,
That's why I came. I didn't believe them.
Okay, that's best, and good luck with that living situation. But let me ask you this: I think you said $50 a day, or did you tell me what your recommendation was if they don't bring it into compliance as ordered? 100?
I will adjust my recommendation to $50 a day.
Okay. What I'm going to do is I'm going to find that a violation has occurred on the. I'm going to still ask for public input, but that a violation has occurred on the property. Grant you 60 days to bring the property into compliance, and if it's not brought into compliance after 60 days, there'll be a $50 a day fine.
Okay. So the car's already had the wheels on. I put it on the very next day, so the car's done. It didn't have the wheels.
Well, they just told me that there's a violation with the Connex.
Yeah, the Connex, I understand, 100%.
That's it.
Is there anything else?
No.
Is there anyone from the public who wants to be heard on this case? I don't see anybody.
Okay.
So that's my order, 60 days, $50.
I'll pay to have it moved.
Your Honor.
Probably
Yeah,
done in
I'm
a couple,
sorry.
probably done in a week or so.
If Ms. Wilson could take the evidence and actually have it admitted for the record.
Okay, it's admitted, no objection.
Thank you.
Yeah.
Thank you.
Exhibits A and B. Thank you.
I'm sure I can have it moved in a week. So
That's all right.
I got 60 days?
Yes.
The violation's conceded, so you don't even need
So what do I do
evidence.
when I'm done?
All right,
Call you?
Next
Thanks, sir.
case, Pete Thomas Jr., case number 2024-718, Code Officer Brandon Norman, page 31 of your agenda.
Ma'am, welcome back. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I will.
I do.
Thank you. Please state your name, ma'am.
Melissa Thomas Bias.
Thank you.
Good
wait,
morning.
what case? Oh, okay, and your last name is Thomas?
My maiden name is Thomas.
Thomas, all right, thank you.
Mm-hmm.
Go ahead.
Good morning, Brendan Norman, Citrus County Code Compliance Officer. This is for case number 2024000718, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 7490 South Myers Point in Floral City, Florida. Property owner listed as Pete Thomas Jr., and I have good service via posting at the property in the Lecanto Government Building. I'd like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during an initial inspection on April 12th, 2024. A corrective action inspection on May 16th, 2024, and my final inspection done yesterday, June 18th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed, as well as the posted notice of hearing at the property.
Ma'am, same kind of deal. I'd like to ask you, first of all, take a look at these documents. Let me know if you do have any objection to them. But number two, are you contesting whether or not there's a violation on the property?
Well, we got rid of the car.
Okay.
Car's gone. You seen that yesterday, right?
Mhm.
Okay.
She's referring to another case that she did abate.
Okay.
It's still debris. It's still a lot of work to be done. The boat, my brother lived there for many years, and he was what you consider a junk man. And when I came home, a lot of stuff has been cleared off, the refrigerators. I did a lot of work to this property, and I guess you can see that yesterday, a lot of stuff been gone. When it comes to the boats, I think that's the only thing you seen yesterday. What else did you see yesterday? One boat is still there.
Well, let me ask you this. So it seems like you're in agreement that there's still an issue.
It's still an issue. I'm a 3-time kidney transplant recipient. My mother lives there and I live there. And she's 90 years old. And,
So you're gonna have her clean this thing up by herself.
So we're living in this house, and it's a lot of work. I did a lot of work to the property, but it's still a lot of work to be done. Financially, I cannot do it at this time. I'm living on a fixed income. I'm trying to save this last kidney. Can't get any more kidneys. It's just been very difficult, but I've been doing what I can do. With this, I need some help. And that's being really honest. I got rid of the car. The person left the car there. I got rid of that. The pool is gone. Some renters were there in this house. They left their stuff at the house. So it's a lot of work still need to be done.
Well, so how much time do you think you would need to get it done?
With the lawn, well, this is old stuff because some of this stuff has been cleared.
Well, don't worry about what's in some of the pages. I guess taking the property as it is now, what's your impression of how long it would take to clean it up?
Well, I was hoping that somebody helped me move that boat. The boat has never worked. I don't know why my brother took boats. I don't understand why. Maybe because they're aluminum or something like that. It's gonna take about 60 days. I don't. They told me I called 2 people, and they both came out. One wanted $2,500 to move the boats. Another wanted $1,800 to move the boats. So it's just been very difficult. I can't get back to work right now. I'm a substitute teacher, and right now I have a hard time just sitting down here today. So it's just been very difficult.
Well, let me. Do you have any objection to these exhibits, first of all?
Some of the exhibit, no.
So, I know some of the photos are old, and I
Yeah.
know there's some improvement,
Yeah.
but do you have any reason to believe that these are fake photos?
No,
Okay.
no.
So what I want to do is I want to get them admitted into evidence so I can look at them, and
Okay.
then I can figure out what time period does make sense based on what you told me. I don't want to set you up for failure either.
Right.
You know, if I give you too short a time, you're going to get hit with a fine that's, maybe not fair, but is there anyone from the public who wants to be heard on this case? Okay. I don't see any response. So you mentioned there were renters, but now you're living on the property?
No, there were renters, but they left.
Oh, they
and
were
they
renters.
left all this debris.
They were there at the same time as y'all?
Yeah. I still live in my house.
Oh.
I live in a house.
Oh, okay.
These was the renters that was in this house.
Okay.
And they had all of this pool and everything like that in this house.
That's it? That boat. I presume you're talking about this boat?
Yes.
Oh, that boat's
That
gone?
boat was gone as of yesterday, yes, sir.
Are you aware that that boat's gone?
Yeah.
Oh, okay. Why do you keep talking about
It's
boats?
2 boats.
There's 2 boats.
So if there is another boat,
Is
there's
there a
one-
hidden boat?
There's one that I can't see.
Listen, I gotta tell you, lawyers sometimes caution their clients about talking too much, you
Shouldn't
never
have
take
said
the
it.
stand, all right, if you're the
See,
defendant.
I've never been to court before.
Let's see,
So she did have another case for unlicensed inoperable vehicles, and based on my inspection, she abated that violation.
all the county's telling me is that some various debris in the front of the house is really, we're talking about
It's some furniture pieces.
which still takes a little bit of time, but it's not 60 days.
They've made significant progress, though.
Well, I still gotta get rid of find somebody to do the debris and not to charge me so much.
Okay,
It takes
no,
time.
I get
It
it. What's
takes
the
time.
county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day, along with administrative costs to begin after the date that you deem sufficient to abate this violation. It was selected based on the actions of the property owners once they're advised of the violation and is appropriate given the severity of the violation and the respondent's actions relative to the violation. We'd also ask the special master of finance respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for your inspection.
Look, based on what you've said about the amount of time it'll take and the photos, I'll give you 60 days. If it's not brought in compliance in 60 days, $50 a day. 2 months,
All right,
okay?
all right.
Good luck.
All right.
Next case on today's agenda, Robert Scott, Barbara K. Hampton, case number 219-68202. Licensing Compliance Officer Timothy Williams, page 17 on your agenda. Sam Acosta and Joanna Coutu, experts on the case.
What's happening?
Sir?
Sorry.
That's okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Robert Hampton.
Thank you, sir.
Rob Hampton.
Okay, good morning.
Good morning. Thank you for the Pledge of Allegiance, by the way. That's a rarity anymore.
Well, if we don't have that, what do we have?
Nothing.
Please proceed.
Timothy Williams, Citrus County Licensing Compliance Officer. This is case number CSR 219-6802, Chapter 18, Article 1, Section 18-A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinance. Address is 9175 East Gobbler Drive, Floral City, Florida. Property owner Robert Scott and Barbara K. Hampton. Good service is signed certified mail returned. Return receipt. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken at the initial inspection on August 2nd, 2023. Photos taken of my follow-up inspection on April 18th of 24, and photos taken at my final inspection June 18th, 2024. Exhibit B, a copy of notice of violation, copy of notice of hearing, and a copy of the pre-hearing order, and a copy of the certified mail receipt indicating good service.
All right, so, sir, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them being evidence, and also let me know if you are contesting that a violation has occurred on the property.
No, I don't deny that they're there.
Now, if you don't deny it, and we'll get into a little bit of the details, do you know how much time it would take you to bring the property into compliance?
It's pretty complex. We have, there were 4 items that my neighbor turned me in for. The
It
pool-
usually is a neighbor.
A neighbor. I'm just going to spare the rest of my thoughts on that.
There you go.
The pool we have removed, yeah, you can take those, Tim. The pool we removed, and Tim was satisfied with that. We still have the hot tub, the shed, and I have not done any further work on the gazebo, once I found out that it was an issue.
So normally
the
you have
pool-
one
the
of two
pool
things
just-
you can do. Normally you either remove the stuff or you get a permit for it.
Right, so we've applied for permits. The shed's been there for 6 years. The pool had been there for 5 years, the hot tub 3 years, and we were building the gazebo. I did not know I needed permits for these. I obviously found out the hard way.
Do you have any objection to these being evidence?
No,
Okay.
they're
All right,
accurate.
they're admitted.
Forgot where I was at.
Well, look, I mean,
So long story
I
short,
understand
we
that they were
have
there.
applied for the permits
Okay.
for the shed and the gazebo and the hot tub.
Okay.
I was gonna just take you through the whole thing, but I'll spare boring you with all that. We've
It's not
applied-
that it bores me. You have the right to tell me, but the hearing will go on.
Yeah.
And so if you know.
It's become complex for us. The permits were denied for several reasons. We would need an additional permit and drawing for the wood and concrete structure under the hot tub. They were denied for the site plan not being to scale And unfortunately, I was told many times that they would help me with that, and when I did the final submission, I went in, presented everything, turned out my drawings for the shed and the gazebo were version 7, they have to be version 8. I went away and I asked, please check everything over and make sure I'm doing everything right, blah, blah, blah. So I returned with the drawings, and I was told that they would help me with this to scale on the site plan.
Who's they?
The representatives at the window.
You're saying the county?
Yes.
Okay.
She said she would do that. Obviously, that didn't work out because it got rejected for it. And also was rejected for the site plan did not show the whole property, all the property lines. Again, I did ask her to look everything over. I didn't know that. I blew it up so that, it was better for detail.
It's a very common process
it's-
that there are submissions and then they're rejected for these kinds of
And then-
reasons.
and then
But
they were
I'm
all
still, hold
rejected
on, I'm still speaking.
for needing
And
a-
then, I'm sorry, sir. And so what I'm trying to get at is, I understand that these things happen, but
Right.
based on your understanding,
Yeah.
do you have any idea how much time you might need to go through this process?
It also requires a stormwater plan. All of this is very, very, very expensive. We do not have the liquid cash to do this. The investments that we do have, we can't even access until the end of August to have the money to do this. Yes, I'm going to comply. Yes, we will fix everything. I'm probably gonna need 5 or 6 months, because it's 2.5 months before I can even access cash money to do this.
Mr. Williams, a violation's been conceded, so what I'm curious about, are you all familiar with the permit that was applied for?
Yes, sir.
And do you disagree with anything in terms of the status of the permit that he said it's been rejected?
Yes, it has.
Okay. And are the issues regarding the permit, do you think it might take, from your perspective, several months to resolve?
Stormwater, and yes, it would.
Mr. Acosta, you agree with that?
The stormwater's pretty involved, right? Yeah.
Okay, okay.
I have been working on it. I went to the engineering company.
You clearly
who
have
did
been
the
working
drawing
on
for
it,
me.
yeah. I don't make any.
And what they were talking about for the stormwater plan was insane.
What's
I
the
did have a
county's-
long conversation with the gentleman who had Quincy
Sir,
Lupex, who
sir,
has
so
my-
you know, I'm already convinced.
Yeah.
They've told me that what you're saying is true. So from my perspective, I just want to give you the time that you need, assuming that they don't have an immediate sanitary concern, Okay.
We do. I do not.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day with the administrative cost to begin at the date of the deemed sufficient to abate the violation. This amount was selected on the actions of the property owners once they were advised of the violations. We would also like to ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order for reinspection.
Sir, this is a nice property. Under your evidence, and I can see that you are making all full efforts to do this. I see that you've already removed some of the stuff that violates the section. I'm going to give you what you've asked for, which is 6 months to bring the property into compliance.
Thank you.
If it's not brought into compliance, there will be a fine of $50 a day, but that's the situation. So,
Okay.
Is there anyone from the public who wants to be heard on this case? All right, thank you, sir. Good luck.
Thank you.
Next case, Michael Floyd, case number 2024-820. Code Officer Cody McGuire, page 14 of your agenda. Expert on the case, Joanna Coutu.
Good morning.
I'm Michael's mom. He can't be here,
Okay,
but I have a letter from him
Okay.
saying,
all right, we'll get to that.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. Ma'am, please state your name.
I'm Dana Floyd, Michael Floyd's mother.
Do you reside on the property or?
Nobody resides on the property.
Nobody
There-
lives on the property?
There are just 3 tents, 3 big carport tents there with tools and his supplies for our store on it.
Okay, well, let me hear first from the county then on what's going on.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 202400820, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 8342 West Katrina Lane in Christian River. Property owner is Michael Floyd. Goods service via posting a notice of hearing on the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 25th, photos taken during a corrective action on May 10th, and photos on my final inspection on June 18th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the notice of hearing posted on the property, a copy of the posting affidavit, and a pre-hearing order.
So, hold on a second, hold on. Ms. Floyd, I have to kind of resolve the issue of whether or not you're just a member of the public, or whether you stand, I'm sorry, hold on, or whether you stand in his shoes. You said that you have a letter from him. Is it a power of attorney?
Yes, he gives me permission to speak for him today. He has a medical condition. He cannot leave his home. If he moves very much, he is going to lose his leg. So I have to do the work for him.
Let's look at the letter then. Would you mind showing a copy to the county?
I got 3 copies here.
Oh, by all means, then I'll take a copy. Everyone can have a copy, and we'll see. Thank you. Let me just review this very briefly. I'd like to hear the county's position on this.
We would object to her testifying as this is not notarized. However, we would accept this as his testimony and admission therein.
Wow.
Um,
Well, I have to say, I've hired somebody to take the stuff off the land.
I'm not quite there
tomorrow
yet.
and Saturday.
I'm not quite there yet, ma'am. What I'm trying to do is we have rules in these hearings about who has the right to speak for people. So, for example, if you have a lawful power of attorney, you stand in his shoes.
I couldn't get it notarized
But so
because he can't leave
what
home.
I'm kind of agonizing over is, there are representations of kind of a disability issue here, and I think that implicates whether or not, there's no ADA override on Florida's power of attorney requirements. So what I'm going to do is I'm going to allow this to be admitted as you've requested and as the county's conceded. Were you there when he typed this, or?
Yes, I was there, and then I went to our store.
Okay.
And printed it off our printer to bring it with us. That's why I made 3
Okay.
copies.
Then, before I get to this, and I have a copy, I still want to hear from the county on what is the case, like what is the violation?
Okay. On April 25th, 2024, I conducted an initial inspection and observed 3 canopies on the right side of the vacant property. On May 10th, 2024, a corrective action inspection was conducted, and there was an additional closed-in trailer and a small utility trailer to the left. And I've had no contact with the property owner, and as of my final inspection on July 18th, the property remains in violation.
Okay, so, ma'am, since Mr. Floyd isn't here,
Yes, sir.
I'm going to allow you to speak as a member of the public,
Yes, sir.
all right? So what do you have to say?
Okay, the small trailer is now in front of his apartment. They will be used Saturday to put the tents on, to take them apart, and put them on it, and remove them and take them to his apartment. The box trailer has since been stolen from his property. It has been known by the law enforcement. They stole most of his tools and his generators out of one of the tents also. So, of course, that trailer's gone also. I have a gentleman I've hired tomorrow to go out and take the rest of the tools and the stuff out of the tents. Saturday morning, before 5 o'clock Saturday, those tents will be gone. And my son will be moving a home in there in the next 3 or 4 months.
So would you say that 15 days is sufficient time to bring the property in compliance?
it'll
I know
be
you've said it'll be done
compliance by
quickly,
Saturday.
but is 15 days enough?
Yeah, yes, sir. I've already paid everybody to take care of it.
Okay.
Because I can't, and Michael sure can't.
I admit the exhibits. I'm not relying on the testimony of the public, but I think it's useful. Now, what is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $100 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Sir?
Yeah.
One more question. Is there anything else on that property besides those tents that need to be removed?
No,
So I
ma'am.
can have it done? So the fence is okay, that he hasn't finished yet, the privacy fence, in the pictures?
Yes, ma'am.
Okay, thank you very
Well,
much.
what I'm going to find is that there is a violation, and I will grant 15 days to abate the violation. And if it's not brought into compliance as ordered, $100 a day. And the email, it's styled as an email from Michael Floyd, is admitted as evidence. Okay?
Yes, sir.
Yes, sir.
Are there any other members of the public who wish to speak? I don't see any. All right, thank you.
Thank you.
Thank you, sir.
Yep.
Next case is Armando O. and Amanda L. Escobar. Case numbers 2024-568, 2024-569, 2024-619. Code Officer Brandon Norman, pages 8, 9, and 10 of your agenda.
Good morning.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name.
Armando Escobar.
Thank you.
Thank you, sir.
Good morning, Brendan Norman, Citrus County Code Compliance Officer. This is for case 2024-00568, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Case number 2024-00569, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. In case number 2024-00619, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 7550 South Myers Point, Floral City, Florida. Property owner listed as Armando O. and Amanda L. Escobar. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence.
Wait a second, sorry. I saw a yawn, and you're not allowed to yawn in code enforcement. This is very interesting stuff. I'm joking, but go ahead.
For all exhibits, the photos are all taken on the same day for the same inspections. Exhibit A will be photos taken during my initial inspection on March 28th, 2024. Corrective action inspection done May 16th, 2024. My final inspection done June 18th, 2024. Exhibit B for all cases will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed, along with the photos of the posted notice of hearings at the property.
So, sir, there's 3 cases here. I do want to ask you to look through these documents and let me know if you have objections. Alternatively, you could also let me know if you're contesting any of the violations.
What's I'm looking at here?
So this is Exhibit A for case number 2024-00668.
What am I, what's the problem, issue?
So you're just reviewing these to see if you contest?
I'll explain. So, sir,
Okay.
what I'm trying to ask is, do you have any objections to these documents being evidence in this
Oh,
hearing?
no, I don't.
Okay.
No.
Well, take a look through them, make sure. And as to the excessive vegetation or growth in excess of 18 inches, do you contest that there's a violation there?
Yeah.
Okay.
This is the last one.
It's all the same, but. I like to look at them though, but yeah.
You don't have any objection to them?
I mean, I was asking him what the issue is and he wouldn't tell me.
No, he did. So he said it while he was over there. So here's what's
I
going on.
wanted to point out in the pictures exactly what he's talking about. That way I can address those issues is what I'm trying to get at.
We'll get to it.
Yeah,
All right.
okay.
Do you have any reason to believe that the photos are?
No.
Okay.
No. I just want to know exactly what needs to be done.
Okay.
Yeah.
Thank you. All right, without objection so far, Exhibits A and B in each case are admitted as evidence. Please proceed.
On March 28th, 2024, I conducted an initial inspection of the property for complaint of junk and debris and unlicensed or inoperable vehicles. I observed the property to be in violation of the original complaints as well as an overgrown vegetation ordinance. I spoke to Mr. Escobar on May 9th, 2024, and we discussed the violations in great detail and how to come into compliance for all three violations. The property remained in violation of my corrective action inspection on May 16th, 2024, and as of yesterday, June 18th, 2024, the property remains in violation with no changes or progress.
Okay. So, Mr. Escobar, let's go through this one by one. You've got a junkyard conditions case, and basically, there's a lot of, it seems like there's some, well,
it said there's vehicles in that picture that are tagged, that's why I want him to point out.
I'm not to that case. First of all,
Okay.
let's talk about the junkyard case. So there's
Junkyard?
junkyard.
It's just a small
Junk
pot.
and debris.
I
Yeah.
wanna see the pictures though, I wanna see what you're talking about, what everybody's talking about.
Okay.
This is my first time seeing these pictures.
All right, and it's my first time as well.
Okay.
So it appears that there is some debris and junk in the yard. So, Mr. Norman, what is still subject to that? It looks like there's been some improvement. No, you don't think so?
The grass got cut.
Yeah. So we're
A
talking about the
portion,
junk and
a portion
debris.
of the grass got cut, but in reference to the junkyard conditions case, there's an area on the backside of the property where the shed is at. It's got a lot of junk and debris, and then because of the overgrown lawn portion, it's an obscured view, but there's still junk and debris that that has vegetative matter growing up through it.
I think is that the only junk and debris issue on this case?
As
Is
far
the
as
stuff
on-
in the back?
Mhm. And then there's also a trailer that has junk and debris on it as well, but the trailer is also subject to the inoperable vehicle case.
What trailer?
All right, so let's let's first talk about the junk case. So it sounds like, and you'll get to see
Okay.
these, there's some junk and debris towards the back of the
I'm not saying
yard.
there's not, there is.
There is?
Yeah.
Yeah. And so that's it for that case. That's
Yeah.
what's going on there, but I
Okay.
welcome, and,
I just wanna see what he's talking about, that way I can address that.
Mr. Norman, do you want to?
Certainly.
I just want to make sure we get this out of the way.
So the first photo is only
Yeah.
an initial overview of the
Okay.
property. We've got a bunch of
This
junk
right here,
debris
yeah, and this, and a
junk
little bit
debris
right
that's
here.
over here.
Mhm. Then this.
More here.
Mhm.
This is another overview.
Okay.
This is from the backside of the property. There's a
That's
bunch
not, that's a lawnmower parked under a
We
carport.
have tires, we have an AC unit that's not attached to anything.
Well, that AC unit's a good unit, I do air conditioning, I'm saving it, and it's
Then it
mine.
needs to be stored or disposed of.
It's under a carport.
No.
It needs to be in an enclosed
Yeah,
structure.
so under the code section, you have to have that stored
Okay,
somewhere.
I can put it in a shed, it's no big deal, but it's
Well,
not
there you go.
junk, it's a
Well,
good
there you go.
unit.
Now you know what you need to do.
Okay,
There's some debris and stuff that's on the trailer.
well, that trailer's empty, there's no debris on it, if you look at it, it's just an empty trailer. I don't know what the
And
debris
still,
is.
as of yesterday, we still have a bunch of
Yeah,
debris.
that's still there, yeah, that, I don't mind
Bunch of
moving that,
tires
yeah.
and everything.
Mhm.
Again, the AC unit's
Okay.
still there. This is just an overview from yesterday. We still have the overgrown area here, all the junk and debris that's behind
Mhm.
that. And
Okay, so that's it. That's the
So you're
junk
talking,
case.
so you're talking about this area here, right? All this in
All
front,
that- all
in
that
front of the
needs
shed, and then I need to clear up back here. Okay.
Okay, so that's
Right.
that case. The next case we'll talk about is the unlicensed vehicle case.
Okay.
Mr. Norman, what specifically is subject to this case?
As of yesterday, there are two RVs that are, appear to be inoperable. There is one gray car that's next to the shed. That's one of the cars that's being overgrown through. On the back side of the property, there's a white pickup truck and also a trailer as well.
So there's a couple.
And then there's also a blue Fiat that has an expired
The
registration.
Fiat, but the Fiat is legal. It might have expired tag, but it has insurance and it's registered, because it's broken.
So you've conceded that's a violation, actually, of the code.
What? No, that's a traffic violation, having an expired tag, but the car is registered and it's legal. It just has an expired
So
tag.
it may interest you.
It drives. It's
May be
operable.
the case.
I'm just saying, like, I don't understand. All the other cars, yes. But that car, it drives. It just has an
Yeah,
expired
let's just
tag.
go through it. So I want to make sure you understand. 20-41, this is Citrus County Code. And here's what it says. It shall be a violation of this article for any person, firm, or corporation to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, junked, disabled, wrecked, discarded, or otherwise unused vehicles or vehicles without valid registration or tag on any property. So you have to understand, that's a violation with the blue Fiat as well.
Okay.
But in addition to, honestly, I mean, there's several others that
Yeah,
are
I know,
as
the
a
other
shame.
ones, yeah, but those are my project cars, but I guess I gotta get rid of them.
All right,
But-
so then let's talk about the overgrown, unkempt lawn case.
No, but let's go back to the vehicles, because
No, sir. Let's
wanna
talk
see
about the
pictures.
overgrown.
I
Hold
wanna
on.
make sure I get rid of all the vehicles you're
Sir,
talking
would you
about.
please,
wanna
all right,
make
you
sure you
you have
get-
the right to look at the photos.
All right.
You just did. Let's talk about the overgrown, unkempt lawn case.
So while portions of the lawn have been maintained, there are some portions on the rear side of the property that are not maintained, such as where the gray vehicle it's the vegetative matter is almost as tall as the vehicle, as well as it's mainly on the back side of the property.
by the shed, right?
Yeah,
Okay.
I see
Once-
that.
Once I clear that out, I'm gonna cut all that.
I see that, and then I see by the white truck.
The
Just a
white
little bit
truck is a
there.
little overgrown, but that's also a wooded area, so I'm a little bit more lenient with that side. If you can get it cleaned up around, I feel like once he gets the vehicles and stuff out of there, you're gonna be able to really tell.
Okay, what photos do you want to see?
Um,
The vehicle ones?
the vehicles, yeah.
You're not aware of the white truck?
I'm aware of the white truck. I mean, so, like you said earlier, I don't wanna say too much, because there's other vehicles, but I wanna make sure which ones I need to move.
The RV is in violation, gray car is in violations, again, the RV.
Wait, hold on, Mr. Norman. You're not aware that there's an RV there?
I never said there wasn't.
You said you needed to see the photos. I'm just curious why you need to see the photo
Vehicles,
of an
cars, 'cause
RV.
there's other vehicles that are not being spoke about right now, so I'm trying to make sure I get rid of the vehicles that are the issue.
All vehicles that are in
Okay, but I
violation.
still wanna see
Sir,
it.
all vehicles that are in violation of the code section that I read
I don't
to
have the
you,
right to see what
whether
vehicles he's
they're,
talking
whether
about?
they're in a photo or not, are violations of the code.
Okay. But
Okay.
I want to see what vehicles he's talking, sorry, I didn't mean to touch you. I want to see what vehicles he's talking about.
Okay.
That's all I want to see.
Okay, let's keep going.
Okay.
Blue Fiat
The
has
Fiat,
expired
yeah.
registration. Again, gray car still
Mhm.
there,
That
truck,
one.
trailer,
Yeah.
another RV, there's the other
Yeah,
RV
that's the same
there.
one, yeah.
That's two different RVs.
Yeah, no, the one you showed me earlier. The-
And then again, showing that it's inoperable, again, as of yesterday.
Now, what's wrong with
truck,
that trailer? Do I have to have a tag on that trailer?
You're telling me that.
You have to have a-
You tell me if you pulled that trailer right now that the tire is not completely flat.
No,
In
I'm
the
not saying that. My
photos,
question is,
it's
what
flat.
needs to be done with the trailer is my
It needs to be
question.
made operable and registered.
It has to be registered, okay. All right.
Again, just another photo of the RV, expired registration for the Fiat, overview of the property.
Okay.
Okay.
All right, fair enough. So, sir, how much time do you need to correct these violations?
I say, I can probably get done in 30 days, but I say 2 months because my work schedule, I work too much. I don't even live at that house. That's my baby mama, that's my kids live there, and their mom.
Okay.
And I live at 45 minutes away, so I get home too late every day. I work out of town, and I'm on call every other weekend.
I mean,
so-
the lawn case is pretty easy.
But I have to clear out the vehicles and the
Okay.
stuff that he's talking about if I can
Right.
cut that grass, because
That's right.
there's stuff overgrown in there.
I agree with you.
Mhm. It's just time, and I
All
can
right,
get
so
it
how-
done.
You said 2 months?
Yeah, I mean, I could probably get done sooner, but.
Okay, fair enough. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with administrative costs for each case to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they are advised of the violation and is appropriate given the severity of the violation. We'd also ask that the special master additionally find its respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection.
Is there anyone from the public who wants to be heard on any of these 3 cases? All right, I'll give you the time you've requested, 60 days. If it's not, on each case, so in all of them, it's 60 days. I agree that they're related. In order to fix one, you've probably got to fix another. And if it's not brought into compliance as ordered, it's going to be $150 a day. So good luck.
Yeah.
All right.
Thank you.
That's per case, you're
Per case.
Next case is on the day's agenda. Johnny A. Gray, case numbers 2024-499, 2024-500. Code Officer Julie Wilkinson, page 15 and 16 of your agenda. Expert on the case, Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Please state your name.
Joni Gray.
Thank you, sir. Now, my agenda reflects that there's two different addresses here, but it's your intention to present them at the same time?
We do it separate if
Okay,
we can.
so which one, we're gonna do 15, page 15 first? Doesn't matter
Yes,
to me.
yes, page
Okay.
15.
All right.
Sorry about
Is
that,
that
Julie.
499?
That is 499, correct.
So, sir, just for the record, you've got two cases. Sometimes we do them together, but
500?
because there's
15.
different addresses, we're gonna,
499.
okay, we're gonna present one first.
So are we doing 499 or 500?
Do whichever one you want, just pick one.
We're gonna do 499 because.
Okay, so
before
that's page
500.
16 of the agenda. That's 2389 South Stanley Terrace.
All right. Julie Wilkinson, Citrus County Co-Compliance Officer. This is case number 24499, a violation of Citrus County Land Development Code, Section 4002, site development without a development order. The address is 2389 South Stanley Terrace, Homosassa, Florida. Property owner is Johnny A. Gray. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 13th, 2024. Photos from a corrective action inspection on April 29th, 2024. And photos from my final inspection on June 18th, 2024. An aerial from the Citrus County Property Appraiser dated July 20th, 2023. And an
Bless you.
aerial from the Citrus County Property Appraiser website dated May 5th, 2024.
That last page was another, it was an aerial?
Yeah, the two were aerials. One from July 20th, 2023.
I got that one.
And
I'm-
then from May 5th, 2024,
And that's, where did you get that?
from the Citrus County Property Appraiser's
Okay,
website.
all right.
Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, so, sir, what I'd like to ask you to do is, when you're presented with these documents, it's an Exhibit A, Exhibit B, let me know if you have any objection to them being evidence in this hearing, and take your time. And are you contesting that a violation has occurred on the property?
What I can say is, these trees, okay, I already cut this tree down, and I cut it up into chunks. After she told me I had never cut another tree. Never cut another damn tree. Darn tree, whatever. And that's a fact. You can ask all the property owners and everything else. They got plenty of witnesses. When she told me not to cut any more trees, I never cut another tree.
Okay.
And I tried to take care of this on the phone, but she had other things, other issues. In fact, she said, I told her I thought there was I had a lot of stuff on this property that I took care of. Wash machines, hauled it all to the dump, tires, needles from people shooting up needles with kids running around on the street that you must have walked over because they were right there, obviously.
Well, sir,
That's
so
bad.
I take it that you're testifying you cleaned up the property.
I cleaned this whole property up,
But-
and people have made very, very big comments how nice it looks.
Let
And
me-
it was trashed.
Let me ask you a couple things. First, I'd like you to at least look through these documents and let me know if you have an objection to them being evidence in this hearing. I guess that's step one.
No, I don't have any objection.
All right. And let me ask right now so I don't forget, is there anyone from the public who wants to be heard on this case? All right. Let me look at the documents then as they come into evidence first. Yeah, take your time. Do you object to that being evidence? You might want to look at it.
what is this one for?
So it looks like there's a notice of violation, notice of hearing in there, which has to do with this case. So the notice of violation is a document that says what they believe you've done, what crime, not crime, what law you've violated, which in this case is Land Development Code Section 4002A. Does that make sense? Do you know why you're here?
What's that?
Do you know why you're here?
Yeah, she's actually, she told me she was gonna, she was pushing for $5,000 fine.
Okay, so that's
pretty,
so
that's
that-
pretty damn rude.
So that's your understanding of why you're here, and what I'll say is.
I flew in from Maine
Okay.
to come to this appointment. I tried to handle it over the phone, and it was about my rocks in my driveway.
This is the case for the trees right now, sir.
Oh.
So this is on 2389 South Stanley Terrace, and my understanding is, I guess it probably, we haven't gotten into the details, but it probably has to do with unpermitted removals of trees or without a site plan. Okay.
Correct.
Okay, so my question to you is very simple. Do you have any objection to this document being evidence that's in your hand?
No.
Okay. Then, if you don't mind, let's give it to the county attorneys, see if they have any comments about it.
I will say one thing though, them trees, that tree had a big dead limb right in it, and
Okay.
it would've came down. And I've cut trees my whole life. I worked 39 years in the tree business.
I actually think that might be relevant. All right, please proceed.
I can,
And she actually said.
Hold on,
I had-
hold on, I'm talking, this is the county's opportunity to tell me what's going on.
I conducted my initial inspection on March 13th, 2024, and observed the property had been modified. Excuse me. While researching the property, I observed that there were no permits applied for or issued. A notice of violation was issued on March 13th, 2024 for site modification without a development order or permit. I have had contact with the property owner several weeks before, on February 29th, where I had warned him, I was there for a different case, and I had warned him not to do anything with any of his properties. He owns several properties along that street, not to do anything without any development orders. And so, and that was on February 29th. On April 29th, 2024, I conducted a corrective action inspection and found no permits have been applied for. As of my final inspection on June 18th, 2024, no permits have been applied for. I spoke with Mr. Gray several times on the phone, as have other people in my office. We all advised him that he cannot be doing any site modifications to any of his properties without these orders. He then told me in the past on one of my previous inspections that he was going to be applying for permits, which he never did. And he also had told me on the phone that he was a certified arborist. I asked him to send me a copy of his certified arborist certification, and then that could let the case go, because then he could say that there was an issue with the trees. That never happened. Here we are.
Okay. What is the site development that occurred that is subject to this case?
He cut down a tree.
A tree.
That I can prove of, yes.
Okay. And is it the county's position that just cutting down a tree, any tree, they have to have a site plan for that?
You have to have a site development order. I would like to introduce Joanna to my expert on the
I
case.
do have to be educated about this.
What do you need?
I'm sorry?
What do you need?
Well, what I need to know is it the county's position that on any parcel that does, I have two questions. Is this residential, do you know?
It is residential.
Okay, so on an undeveloped residential parcel, if someone cuts a tree, if the owner cuts a tree down, is that a violation of 4002A?
Yes, if it's a tree, that it is.
And why is that? I mean, what in the code says that cutting a tree down is development? Or why should I believe that?
It's under the definition of development in the code.
Where's that?
It's in the front of chapter 1.
All right, let's see.
I hope so.
I think you're right, but I just want to make sure I understand. All right, so development. The carrying out of any building activity or mining operation, the making of any material change in the use or appearance of any structure or land, or the dividing of land into 3 or more parcels. And I know that in prior cases, we've gone over what material change is because, you know, when someone clears a lot, that's a material change. When there's a substantial clearing, that's a material change. The reason why I'm asking is because I'm having a hard time understanding how cutting one tree down is a material change, especially when the property appraiser aerials that are admitted as evidence, I mean, of the trees that are there, this is a very, I just don't know how to say it, but I mean, it just doesn't look material. Everything else is still there. It's one tree. There's a lot of other trees. Why is this a material change? And if it is a material change, doesn't that destroy the meaning of the word material? In other words, why is material there? Why wouldn't it just say any change?
I'm looking over
I know.
to Ms. Harrison too, but I don't know if she, yeah.
I mean, does my question make sense?
No, it
No?
does.
Oh.
If I, actually, could I approach and look at the aerials that you're discussing?
Yeah.
Okay.
It's in evidence, Exhibit A. It's the last 2 pages.
So at this point, the county's position would be that it is material. It does have an impact on the land. The aerial that I just observed and is in evidence, even though it is in the terms that I believe the defendant has used, only one tree, one tree can have a very large impact. It's not a tree that is minuscule. You can actually see it. It appears to take up, the canopy appears to take up about half of the lot size. And I don't know if it would be Ms. Coutu or Mr. Acosta who would be able to testify as to the impact on the land, the runoff, that the disturbance and how this changes.
How would removing that tree have an impact on the runoff? I mean,
Unfortunately, the individual who previously testified regarding all this wasn't here. It isn't here right now. So we've had other cases where the impact of rain, water, air, and wind and mitigation and different mitigation things that have to happen. Once you remove the tree, you start disturbing how the water absorbs, how the wind and affects the sand and affects the actual area, which is why we have such a broad definition of
wind is a
our-
good point.
of our in our code. And I know, I apologize, I'm
Well,
not.
wind is a good point. I don't buy the other stuff right now, but do you have something? I'm going to reserve on that. I'd like to hear what you have to say.
Well, I would like to show some pictures of the road.
If you
that,
would, show it to Ms. Wilkinson.
She actually said that she had no way to contact me, but there's my mailbox that's been there for I don't know how many months.
All right, so this is,
object to this.
okay, and what's the objection?
It's not the property we're talking about.
Okay, so we're just talking about 2389 South Stanley, and did you testify that you couldn't get in touch with him? Because I thought you testified you had
I
conversation
did
with
not
him.
testify that I couldn't get in touch
Right.
with him. Yeah.
Didn't you tell me on the phone that you
Sir,
had no
sir,
way
sir,
to-
sir,
to
sir, you have to
meet with
direct your question. Y'all shouldn't directly talk to each other. Yeah, but
On the phone, she told me she had no way to contact me. Now, I put this mailbox in way into the beginning of the year. I put the mailbox in, went through the thing with the mailbox guy that delivered. Right next to her, Brian Stevenson's wife delivers mail. That was all perfect. Today,
I don't think notice is an issue. I mean, is notice an issue? Like, are you saying that you didn't get notification of the
She was
case?
telling me that I didn't get notification because I didn't get it until I got home.
The only notice issue would be raised by you, so I don't really, I don't really, with all due respect, I don't really care what the county says about that, because you're the one who has to raise a notice issue. You're
Yeah.
the one who'd have to be like, I didn't know about it.
Yeah.
Sounds like you
Well,
did.
This is some of the, you're talking about the water issue. This is the road, the road that my property is on.
What I'd like you to do is any photo that you want to introduce in evidence, show to Ms. Wilkinson. She may talk to other representatives of the county, and I'd like to know the county's position on if you have any objections to these photos. And they may ask you what they're for, and then we'll talk about it, but let's see.
I object to one photo. Am I allowed to object?
I mean, I
Okay.
would rather that you work with the,
Okay.
When did he?
That did not happen from that tree.
hold on.
When did he take these photographs, just for foundation?
Sir, when did you take the photographs?
I could have took them all the time, but I took them, March or April, I don't know.
Okay, a few months ago?
A few months ago, yeah.
Okay,
Every time it rains, it's like that.
okay.
That road is impassable, and that's why the mailman does not deliver mail past the mailboxes.
I don't know why is that relevant?
I just, to take one tree down, I mean,
I think I see what you're saying. Okay.
jeez, I'm crying.
Okay.
So at this point, we would object, first, the one with the fire feature, this isn't that property.
That property, okay.
And the rest of these are all of the road, which again is not that property.
But
My property attaches to that.
the road isn't adjacent to the property?
My property adjacent to the road.
Yeah, and so I think what he's saying, correct me if I'm wrong, is that these photos are relevant because how could this tree be a material change when it's already so screwed up over there?
You got it.
Okay. I don't know. So I'm not going to admit, would you mind delivering this back? I agree with the county about I don't know why that's relevant. But these other 4 photos, I will admit for whether or not the removal of one tree is a material change. Because both sides are talking about impacts to, but you're gonna have to talk to me about these. So these are gonna be Exhibit C for now. And so now would be a good time, actually. What do you want to tell me about these photos?
That's how bad the road is, that my property is up against. That's where I come out
What part of the
onto.
road is the property up against?
My property's on the left-hand side of them pitches.
Okay.
And my property runs, I got 5 lots there. All 5 lots adjourn to the water. And there's all kinds of car parts right where the mailbox ends. And I took pictures of it today, and I could show you on my phone. It's probably a dip like that deep. And every time cars go over it that live down that road, they rip parts off their car.
Well, I
They
mean,
go over on my property to go around, to divert around the water.
Ms. Wilkinson, can you tell me about the certified arborist issue? So, could you talk to me about that?
So he had said that the tree was diseased or dying. I said, okay, do you have a certified, a letter from a certified arborist stating that? And he said, well, I'm a certified arborist. I said, okay, send me a letter and send me a copy of your certification. And he never did.
And so, sir, your testimony today was that there was a big dead branch on the tree. Was the whole tree dead, or was it the big
One whole
branch?
leader on that tree was dead.
Okay.
If I could just address 2 points. Ms. Wilkinson, his question was, why does the arborist matter? Is there something in the code that would impact why an arborist is important in that?
To my knowledge, there's nothing in the code about that, but it is policy that if a tree is presenting like a danger.
I think there is something. I know we've dealt with it before.
Maybe it's Ms. Katu needs
Yes.
to answer that
Well,
question.
I don't need a fact witness.
Okay.
Anyone can tell me. I mean, where is it?
Ms. Katu, do you have the number or where in the code that would be?
It's in the tree removal chapter, the landscaping chapter. There is a statement, it mirrors Florida statutes. It says if you have an arborist certify that a tree is dead or damaged, it can be
Do
removed
you
without
know
a permit.
around where that would be?
Sorry, I'd have to approach.
Is it 3710? I'm not sure. 5710?
5710. That sounds pretty good.
Maybe.
I'll tell you what, not too bad. I think you're right there.
Good job, JC.
Every now and again.
General provisions. These are exceptions. Okay. Okay, this is relevant. All right, let me take a look at this. So what I'm doing, just so you know, sir, is I'm looking through the code. I'm trying to figure out where the tree issues are.
This is, can I
If
show you the
no,
picture?
just give me one
No?
second to read this, if you don't mind.
Yep.
Is there anything else either side wants to say?
Just that, Your Honor has previously received, this is going back to the original question you asked me about material, briefs on this issue, which cite cases such as Florida Power and Light and Berman, which dealt with the court addressing the ecological concerns for the destruction of trees. And we do have that, and if you want to go into more detail, I can, but it
Is
goes
it a
back-
case where a material change is one tree coming down on a piece of residential property?
It's looking at the irreparable or irreversible nature of tree removal. This brief actually cites 3 different cases. I don't have in front of me in the brief the number of trees, but that the removal
Because
is.
where we're talking about tree removal, I agree. I think clearly it's a violation of section 5710 or 5715. It's clearly a violation of the tree removal statute. That's not what we're here for. I am not going to find that taking one tree down is a material change for development purposes. This is good and bad news for you, sir. So let me explain what I'm doing in this case. I'm dismissing this case I do not find that taking that one tree down based on the aerial views and the other photos I have is a material change. Because if it was, then anytime someone takes a tree, it's not just a violation of the tree removal statute, it's also a violation of the development statute. I don't think that's contemplated under the code. I think it reads material out of the statute. I do think you've committed a violation by taking the tree down of section, broadly speaking, it's 5,700 on, and just so you know, this code protects trees that have 4 inches or greater diameter. So they could come out and cite you for that, and then you'd be right back in front of me. So that's my ruling on that case. FYI.
Thank you.
All right.
Can I show you these pictures here?
You've already won that case, so
Okay.
I don't really care to see any other evidence.
No, that's good. Okay.
Why don't we go to the next one?
Okay. Should I introduce myself again?
No, go
Oh,
ahead.
okay. This is case number 24500, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. This address is 2349 South Stanley Terrace, Homosassa, Florida. Property owner is Johnny A. Gray. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 13th, 2024, and photos from a corrective action inspection on April 29th, 2024. Photos from my final inspection on June 18th, 2024. An aerial from the Citrus County Property Appraiser's website dated July 20th, 2023. And an aerial from the Citrus County Property Appraiser's website dated May 5th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, so sir, again, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence in this hearing.
Well, in this hearing, I took care of this, all of this problem, but,
Well, without, I don't,
Yeah, no,
you'll be
no,
able
that's
to,
good.
so you'll be able to talk about what's in the photos later, but I just want to know if you object to these documents being evidence in this hearing.
no, but, I can tell you something, I stayed there last night in the rent-a-car.
You stayed on the
I
property?
flew in last night at 12 o'clock, I slept on my property in a rental car, laid the seat down. So is that a violation?
Yes,
So I'm guilty.
correct. I hope,
Yeah, I got 4 hours sleep, about 3 maybe.
well, join the club. At any rate, do you have any objection to these documents being evidence? That's the question.
No.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see any response. Aren't you from Maine? Aren't you from Maine? Aren't you
I am.
still riding high on the Celtics winning the championship?
Well, I'm gonna tell you something, I watched that and I'm so happy.
Okay.
Very happy.
Just think about Jaylen Brown and Jason Tatum to get you through
It
this.
was great,
And,
I'm telling you, they did a great job. They played a great series.
Thank you. All right, without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
Yes. So, Mr. Gray has installed a limestone driveway and parking pad on this vacant piece of property.
Okay.
You want the dates?
No, no.
Okay.
And it's in the photos.
It's in
This
the
is what
photos,
you've
yes.
taken the photos of. Do you know about when he did it? Just without, he'll probably tell us, but I'm just curious if you know.
I only know from what I observed on the day I took the photos,
Okay.
which would March 13th.
Do you know what she's talking about? I mean, you've
Both
already
the-
testified to it.
About the rocks, yeah.
Yeah. You want to tell me a little
That-
bit more
you know,
about
she's
what?
saying I put a driveway in, and that's no driveway. I mean, I put it in so I could get my Mustang off the property, off the road, on my property. And then I paid for 22 yards and only got 5 yards. So the dollar wheels on the dump truck weren't even touching the ground, and I got winged for, I'm telling you, I've learned a lot about a lot of things fast.
So part of the reason why this code section exists is that, as they've said, is the county needs to understand and approve the kind of impacts that you have. When you go ahead and start developing this property, it's gonna have impacts at some point. You know, you'll put impervious in, there's runoff, there could be grading issues, that kind of thing. I found in your favor on the first case because I don't think taking that one tree was a material change, and I think they frankly can still nab you under the tree statute. On this one, I do find this is a material change. This is you changing the nature of the property a little bit. You're improving the access to it. Does that make sense?
At least I can get my car off the road.
No, I know why, but that's why it is a material change. You're changing your abilities, what you can do on the property, and that is a development-related thing, and you're admitting that. So, I mean, look, whether people like it or not, these are the laws that we have to follow. And so I encourage you to retain either legal counsel or help in what you do to the property and development. It sounds like they did tell you, you know, don't do this kind of thing without talking to them first. So.
It's not a driveway by any means. It's just a darn thing. I mean,
It's not a good-looking driveway, that's true.
I would not consider it a driveway by
Okay.
any means.
All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,500 along with the administrative costs. This amount was selected based on the actions of the property owner once he was advised of the violation.
So, Mr. Gray, we do have these cases fairly regularly, and in order to be consistent with the punishment that we normally give, it normally is a fine of about $2,500. That is what I'm going to assess.
Oh, my God.
You can appeal any
You know,
order I make.
don't even, I'm
Yep.
gonna appeal.
All right.
it.
Thank
Yeah,
you, sir.
Thank you.
Next case on today's agenda, Lofton S.
So
and
the other one's been dropped, and this one's 25. Oh, boy.
Next case, Lofton S. and Charlene A. Ewers, case number 2024-656, Code Officer Cody McGuire, page 11 of our agenda.
I encourage you to retain legal counsel or appeal it on your own, but that your hearing's over.
Oh, boy.
This is page 11?
Yes, sir.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Please state your name.
Melissa Powell.
Thank you.
I'm here because my mom is in the hospital. I have power of attorney over her.
You do have power of attorney?
Yeah.
Okay. And who's your mother?
It's Charlene Ewers.
Okay.
Lofton Ewers, her husband, shot and killed himself in March of this year. So, with that being said, that's why I'm here. My mom's been in and out of the hospital, got a lot going on. I tried to return, I called 2 or 3 times the number that was, the notice, the pink notice that was left on the door.
Well, ma'am, let me, the thing is you're talking a lot already about like what's going on, but I don't even know what the county's case is. So
Okay.
with all due respect, I'd like to hear from the county about what they are here for today.
Okay.
And then I'll get to your position and what's going on. Hey, good morning.
Morning, sir. Cody McGuire, Citrus County Code Compliance Officer. This is case number 202400656, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 4235 North Mandrake Point, Christian River. Property owner is Lofton S. and Charlene A. Ewers. Good Service is posting the property and posting at Lecanto Government Building. I would like to authenticate the following documents and be admitted. and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on April 8th, 2024, corrective action inspection on April 25th, 2024, and my final inspection on June 18th, 2024. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
Okay, so ma'am, now I'd like to talk a little bit about your position here today. Do you have a copy of the power of attorney, or you're representing that there is one?
I do. I don't know if I left it in the car or if I left it. I've been having to show it to so many different people. I don't know if I have it in the house or if it's in my car. It might be in my
Okay,
car.
that makes sense to me.
Anyways, go ahead.
Are you, let's assume for a moment, and the county may object, but let's just assume for a moment that you have a power of attorney. Are you contesting whether or not a violation has occurred on the property?
I'm just here because my mom can't be here.
Okay.
And I am doing everything that I can to help.
Okay.
If you.
We would take that into account.
We're trying to clean
Yeah.
up the property. My mom is ill. She can't do it.
Well, that's what I mean.
I'm
I mean,
one person trying to do it.
are you familiar with the property?
Mhm.
Do you know if there's junk and debris on there?
Yeah, there is, but
Okay.
that's, my mom is in bad condition.
Okay.
And I can't do it all overnight.
No, and no one's gonna accuse, I mean, I think you've been here for the whole hearing.
Yeah.
You know, no one is forcing people to do stuff overnight unless there's a sanitary or health concern. And maybe there is one here, I don't know. But I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence at this hearing.
I don't understand why you never called me back. I called to speak with somebody about this, and nobody ever returned my call.
Ma'am, would you bring the microphone down just a little bit so that we make sure, yeah, thank you.
Okay, yeah. Okay, well, most of this is already taken care of, so I did all this.
Okay.
This is not like this no more.
Good.
What's wrong with that? My dad had that up. I just need to know.
So ma'am, my question is actually a little more simple. We'll be able to talk about what's going on the property, and we'll be able to look at the photos. I just need to know if you object to these photos being evidence in this hearing.
I got most of this cleaned up, so from what I'm seeing, no. Yeah, I got all that cleaned up. What is this?
That's all the notices.
Where did you leave these at?
No, hold on. I need to know if you have objection to these documents
I
being.
just said no, sir.
Oh, you
said
did?
no.
Okay, good.
I'm
All right,
sorry.
then let's, Mr. McGuire, can you please take the documents, show them to the county attorneys? And is there anyone from the public here to speak on this case? All right, I see no response. Okay, then without objection, what's been proposed as Exhibits A and B are evidence. Please proceed, Mr. McGuire.
Okay. On April 8th, 2024, I conducted initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On April 25th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. I've had no contact with the property owners. As of my final inspection on July 18th, 2024, the property remains in violation.
All right, so I'm looking at the photos that were taken yesterday. Yesterday was June 18th, right?
Yes.
Yeah, okay. I mean, I see it. So based on what's still there, ma'am, how much time do you think it would take to fix?
You took this one yesterday, you said?
Mhm.
Yes, ma'am.
Well, I did this all last night. So, it's nothing like it looks
Okay,
there, so.
then how much time do you need to clean it up from where it is now?
I mean, I only have, what do you think? I don't have that much left to do.
Is
No,
30 days, is 30 days enough?
2 months at least. I would say, just to make sure, because I don't want to cut myself short on time. My mom's going through a lot of doctor's appointments.
Okay. Do you have any health sanitary concerns?
No, sir.
Okay. Then what I'll do is I will find that a violation has occurred. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $150 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I'll allow the 60 days requested, and it'll be $150 a day if it's not brought into compliance as ordered, okay?
I do want to say this, though. I can prove it by phone records. I did return I returned calls. I never got a call back. I did, personally, myself.
Okay, thank you very much.
Next case on today's agenda, Ashley E. Locke and Cynthia G. Bertelli, case number 2024-845, Code Officer Julie Wilkinson, page 19 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state both your names.
Cindy Bertoli.
Ashley Locke.
Thank you.
Is that a yes? I just didn't hear it. You swear? Okay,
Yeah.
gotcha. Thank you. Please proceed.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 24845, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6860 South Ridge Point in Homosassa, Florida. Property owner is Ashley E. Locke and Cynthia A. G. Bertoli. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on May 8th, 2024. Photos from a corrective action inspection on May 24th, 2024, and photos of my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right, so ma'ams, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
We
Already looked at them.
Okay. Do you contest that a violation has occurred on the property?
No, but what we got was, the number when we got here for the violation, was something where actually, we had been to put a shed on the property without getting a permit. So we took it down. So when we walked in here today, we thought that's what it was. But then the lady said, no, you're here for this case number 845, which we never received anything on this case 45, which these pictures are real.
Okay.
This is true. But we didn't realize that
You were here today for a hearing on the junk case.
for the hearing on the.
Now are you making an objection to having the hearing based on the junk? You've already
No.
conceded that there is junk.
Yeah, there's junk, but we also took down a shed, you know.
Yeah, and you're not here on that case. It sounds like they've abated it. It's not here
Yeah,
for a hearing.
yeah.
Whatever it is.
Yes,
Okay.
we're guilty of this.
Okay. Now, what I want to know is how much time do you need to bring the property into compliance?
30 days.
Okay. Ms. Wilkinson, how did you deliver notice for this case?
I initially sent the notice of violation, certified mail, as well as a notice of hearing. I did not get good service, so I posted the property and the Canto Government Building was posted.
You posted it for the junk case.
Yes, sir.
Was there another case?
There was. I was not handling that case.
Okay.
It was a license compliance case.
Gotcha. Do y'all live at the property?
I do.
Okay, and you didn't see the posting?
I did receive the posting and I signed off on the posting for the shed, which is the same date that y'all said that I'm in compliance for the debris.
Okay.
And I have the statement that I signed off for, but I never received another person that came and knocked on my door, because I have a Ring camera and I answer everything.
Okay.
And so I never received notice for this one, but even when I received notice for the first one, that was the only thing that was supposed to go to my house. All the other mail was not my address.
Okay, let me just take a look through these exhibits. Yeah, I mean, there's a picture in here of the notice posted on the property on June 7th. I mean,
got that. I got that one where they staked it in the
Yeah.
ground. That's the first one I got.
That's
And that
this
one
one.
shows that I have to go to court.
yeah, well, so that's what I'm taking. It actually
Yes.
refers to the case number. It is this case.
Yeah, I didn't think to look at two different case numbers.
Okay,
I'm
no
sorry.
problem. No,
I only.
that's okay. But what I'm going to do is I am going to admit it as evidence.
Yeah, yeah, you're
All right,
fine.
what's the county's recommendation on this?
$100 per day, along with administrative costs to begin after the date you deem sufficient.
I'm going to give you your 30 days that you requested to bring the property into compliance. I do find that there's a violation based on your testimony and the exhibits that are admitted into evidence. If it's not brought into compliance as ordered, how much?
$100.
It'll be $100 a day. So that's it.
Thank you.
Thank you.
Thank you.
And I'm sorry, is there anyone from the public who wants to be heard on this? All right, I don't see a response. Thank you, ma'am.
Next case, Russell and Christy Richmond, case number 2024-751. Code Officer Julie Wilkinson, page 27 of your agenda.
Ma'am, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Can you please state your name?
Christy Richmond.
Thank you.
Good morning.
Morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation. Initially observed on April 25th, 2024. The address of the violation is 6420 West Folger Court, Homosassa, Florida. The case number is 24751, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owners are Russell and Christy Richmond, and they have previously been found guilty of the same violation at the same location on July 29th, 2019, and that case number is 253178, with $0 in imposed fines.
Bless you.
Bless you.
And that case was abated on August 29th, 2019. I have good service via posting of the property and posting at the Locanto Government Building and signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts in order acknowledging compliance from previous case number 253178. Exhibit B, photos I took during my initial inspection on April 25th, 2024, and photos I took during my subsequent inspections on May 3rd, 16th, 24th, the 31st, as well as June 7th and 14th, and photos from my final inspection on June 18th, 2024. Exhibit C, a copy of the notices of violation and hearing sent to Russell and Christy Richmond, a photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, a copy of the posting affidavit, and a copy of the signed certified mail return receipt.
All right, ma'am, I'd like to ask you to take a look at these documents. Let me know if you do have an objection to them being evidence. And
Okay.
Take your time.
Well, first of all, I don't have my glasses. I can't read this.
Okay. So Exhibit A is out. Exhibit B, there are photos. Can you see the photos?
Yeah, I can
Okay.
see the photos.
All right. Exhibit A has to do with the prior violation on the property from about 5 years ago. And I don't know if I was the hearing officer in that case or not. Do you know if I was? No, it's okay. It's
No, this isn't from 5 years ago.
Okay.
Yeah, this is recent.
Do you contest whether there's a violation on the property?
No, there was, yeah.
Well, I mean, is there today?
I hope not. We
Okay.
got everything cleaned up. I hope it's up to standards.
Okay.
She was out there yesterday, I was told, but I was at work.
Was it brought into compliance yesterday?
No, sir.
Last night.
Oh, I see.
We finished up last night,
Okay.
and I'm hoping it's up to standards. I
Okay.
did take some pictures off of my phone this morning before I came in.
The problem is I can't take your phone.
I know.
Yep. All right, so I didn't hear an objection to the exhibits. I understand that you don't have your glasses.
Yeah.
But what they've said and what's in Exhibit A is that there was a case about 5 years ago on the property, back in
Yes.
2019.
Yes, this is recent
Yeah.
because my dad had an RV in my yard, and I tried for the longest time, because it was an eyesore, to get it off my property. Well, he passed away a couple years ago. My mom didn't want it. It was non-livable, so my boys went out there and they started cutting it up. That's where all of it came from.
Makes a lot of sense.
This round. We were actually like 2 weeks behind on getting it cleaned up because we all got sick in the household. And this was before she showed up with the letter, so.
Okay. All right, let me just take a look at this. Without objection, what's been proposed as Exhibits A, B, and C are admitted as evidence. Is there anyone from the public who wants to be heard on this case? I don't see any response, but just briefly looking through so that I understand. Yeah, either they were cutting something big up or a bomb went off, one or
It
one or
was
the
an
other.
RV. Yeah,
Um,
it still had a bunch of stuff in it, and we
I do see
pulled all that
improvement.
out.
I mean, Ms. Wilkinson, would you say there's been improvement?
Oh, massive
Yeah.
improvement.
Okay. All right, please proceed.
I conducted my initial inspection on April 25th, 2024, and observed loose trash, auto parts, scrap metal, tools, miscellaneous junk and debris on the property. I posted a repeat notice of violation and notice of hearing on the property on April 25th, 2024. I conducted subsequent inspections on May 3rd, 16th, 24th, 31st, and June 7th and 14th. There has been substantial improvement in the condition of the property. As of my final inspection on June 18, 2024, the property remained in violation. I have had contact with the occupants on several occasions, and they've always been very positive and have been steadily been making progress.
That's the good news. The good news is that I can see that for myself. I would take that into account in any penalty. The bad news is this is a repeat violation. So what that means is, based on the fact that you had a violation 5 years ago, I'm going to impose a daily fine from the time that the property went back into violation, which is April 25th until until today, to be honest.
I don't understand what you mean.
What I mean is, normally on a regular case, if you didn't have a prior violation, like take your case from 2019. So in this case, there's an order from my predecessor that said, if you don't fix the property within 30 days, you'll have a $50 fine. But it was an automatic fine, and indeed, you brought the property into compliance within the 30 days, so you never had a fine, okay? But what the Citrus County Code says is, if it happens again, from the date that the property goes into violation, you're liable for a fine, as determined by me.
Okay, I wasn't aware of that. Okay.
So I'm just trying to explain it. That's the bad news. All right? So is there anything you want to say about what's going on in addition to what you've already said, or mitigating circumstances, that kind of thing?
I mean.
She said you've worked with them, so.
Oh, yeah. I met her once. I think she's met my boys, and I think she might have met my husband. I'm not sure. My husband's disabled, so he can't get around much. So it's been me and my boys majority of the time cleaning it. But
Well, how much time do you think I think you've testified that you think it may already be in compliance, but if it wasn't, how much time would you need to be sure? 15 days?
I would say a couple of weeks, but if you could give me 30 days just to be on the safe side and make sure everything is up to par.
I'd rather do that, just not to set you up for failure, although honestly, the property looks pretty close from the photos that you took yesterday. I do find that there's still a violation, though, on the property.
Yeah.
What is the county's recommendation here?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative costs, begin on the date of the posting of the property, which is April 25th, 2024, and continue until June 18th, 2024. That would be 55 days at $50 a day, totaling $2,750, and a fine of $250 per day from this day forward until the violation is abated. We would also ask the special master to find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So I am going to adopt the county's recommendation. 50 is the lowest they've ever gone on any kind of fine, so I think that's a tribute to your cooperation with them. And so I will assess that fine that runs from April 25th to June 18th at $50 a day for 55 days, okay? Now, from today's date forward, because it is a repeat, there's an elevated fine. You had $50 a day on the last case. It's now going to be $250 a day. So I would call Citrus County immediately, when you think the property is ready. I know you've already said today you think the property's ready, so if it's ready today, there may not be much of a fine, okay, going forward. But it is going to be $250 a day going forward until it's fixed.
Okay, how would I go about the fine thing?
That's a question for the county. I'm going to sign an order about what the fine is. How you pay it, how you work out the payment is between you and the county.
Okay.
Okay? That's it. Thank you.
All right, thank you.
Next case, Julie Martin and Ellie Burke, case number 2023-1347, Code Officer Julie Wilkinson, page 20 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Julie Martin.
Thank you.
Good morning.
Good morning.
All right. Julie Wilkinson, Citrus County Code Compliance Officer. Case number 23-01347. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4701 South Apostolic Point in Homosassa, Florida. The property owner is Julie Martin and Ellie Burke. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on December 15th, 2023. A corrective action inspection on April 30th, 2024, and photos from my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
So, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And also, you can let me know if you're contesting that a violation has occurred on the property.
No contest.
No contest, okay.
When is the last time, did you come out yesterday? Did
So
she come-
you'd have to direct your comments to me.
Right,
I think your
sorry.
testimony was that you went out yesterday.
Yes, sir.
And there's still a
Oh, okay.
violation?
Yes,
Okay.
sir.
So the question is, how much time do you need to bring the property into compliance?
If I could have at least 60 days.
Okay, I'll take a look at the photos. I mean, are you objecting to the evidence? Are you
No.
objecting to the photos? Okay.
No, I knew it was a mess.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see anybody, so let me just take a look. And exhibits A and B are admitted.
Sir, I just wanted to state that I've had a lot of people stay there and leaving their things. They seem to like to do a lot and just take off and leave it for me to clean up after, and I haven't had the easiest time. So,
I
giving
believe that.
the
I mean,
time
yeah.
is really needed.
Okay, what's the county's recommendation?
I would like to go into the history of this,
Yep,
if
all
that's
right,
okay.
fair enough.
All right. On December 15th, 2023, I conducted an initial inspection and observed loose trash, auto parts, discarded appliances, furniture, lumber, miscellaneous junk and debris on the property. On December 15th, 2023, a notice of violation was issued for an accumulation of junk and debris, which is a violation of the Citrus County Code of Ordinances. On April 30th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. As of my final inspection on June 18th, 2024, the property remains in violation. I have had contact with the property owner who has been kind and allowed me onto her property, but only in the front section, not the back section where most of the junk is. I have given her multiple extensions to come into compliance. As you see, the case has been going on since last year in December. She has moved stuff around and organized it, but not really removed a lot of the junk from the property. And now there is a type of privacy fence being erected to obscure view into the back of the property where the majority of the junk is.
Are you, I mean, right now, do you have a sense of the entire violation on the property? Or are you do you not know?
I know, I have seen the junk in the back of the property, yes, and there was a lot.
Okay. I mean, do you think that they can clean it up in 60 days? Is it that much? I mean, I guess when I know you don't, I'm not.
I don't know, they've been given 6 months to clean up
Yeah,
what was there, and they
I get it,
haven't.
yeah.
I think it's doable, but whether they do it or not, that's a different question.
I get what you're implying. Okay, so, ma'am, I guess the deal is, it's true. I mean, the first photos here were taken in December. That's half a year ago.
The trailer, there was a huge trailer there that was full of stuff. That's gone. There was a truck there. There was 2 trucks there. Those are gone. There was another trailer there full of debris. That's gone. I have gotten stuff done there.
What's
Other
going
people
on?
to do it, but
What's going on with the fence?
the fence is to try to make it look better because there still is junk back there.
Well, you understand
But
that whether
I
you put
didn't
up a
move-
fence or not, junk and debris is junk and debris.
Right, but
Okay.
it just looks a little bit better from the yard. I mean, from the street, We have new neighbors, and it isn't pretty back there, But I have gotten rid of a lot of stuff. I have.
So, Ms. Wilkinson, I may be missing, but what is, for your purposes and
Yes.
the work that you do, what is the issue with the fence? Is that are you worried that once fully erected, you won't be able to tell whether or not it's been brought into compliance, especially if they say, no, you can't come back on the property?
Exactly, and also the amount of junk, it's posing a safety issue. She's got a lot of people coming in and out of this property. The police and paramedics and fire department has been called out there multiple times, and it's a safety issue.
So you have a health, safety, sanitary concern?
Yes.
And have you seen other folks occupying the property or
I have
strolling?
seen numerous different people on the property and spoken with different people on the property when she wasn't available to speak with me, and I've never spoken to the same person twice.
Are they going to the bathroom there? Are they living there? Are they staying there?
I can't say for certain what is going on at that property.
Okay. So, ma'am, I think I am now concerned about the property based on the testimony, and you have also admitted that people are staying there. I don't see any.
I have 2 roommates,
Okay.
and there was people staying in the back. The people in the back are gone.
Okay.
And one of the roommates is here with
Okay.
me,
All right.
and the other one told me that he talked to her twice.
Okay. How many?
That was the tall one.
How many structures or houses are on the property, or?
There is, are you asking me?
Yes, I'm sorry.
Okay, so there is one mobile home and at least one RV that I know of, which she's denied that anybody is living in. And that's why I don't know now if there are other tents or if there's anything else. That's just what I observed initially, which was 6 months ago. Things could have
What's the
changed.
county's recommendation again?
$150 a day,
Okay.
along with administrative costs.
All right, so.
You
kn-
can come back there and check it if you don't believe me.
Well, ma'am, it may be necessary. So what I'm going to do is, I do believe you that there's been some test improvement, but it has been 6 months already. Usually they don't wait this long to bring a case like this, and I have to agree, based on the testimony, that I think 60 days is too long. So what I'm going to do is I'm going to grant 30 days based on the concerns that have been expressed, and if it's not brought into compliance as ordered, there will be a fine of $150 a day.
Thank you.
All right, thank you. And I'm sorry, is there anyone else who'd like to be heard on this case? All right, I don't see anybody. Thank you.
Next case, Jacqueline Shade, case number 2024-42. Code Officer Julie Wilkinson, page 28 of your agenda.
It's the Julie show today.
It is. It is.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Jacqueline Shade.
Thank you.
Good morning.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2400042. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4201 West Road Runner Court in Homosassa, Florida. The property owner is Jacqueline Shade. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on January 11th, 2024, a corrective action inspection on April 29th, 2024, and photos of my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, ma'am, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them. And also let me know if you're arguing that there's a violation or is not a violation.
I'm not arguing that.
Okay, so you agree that there is a violation?
Yes, sir.
How much time do you need to fix the violation?
Originally, when she came to my house, we talked, and she gave me like 30 days, okay? And then she came the 30 days later, and then she said, well, look, you guys are moving it pretty good. She said, I'll give you another 30 days if you need it, and maybe even another 30 after that. Well, she came back the first time, but she didn't come back the second time.
Okay, but how much time do you need from today?
About 30 days, if I could have that.
Okay, then I'll take a look at the.
It's almost completely done. I've got pictures, but they're on my camera. My camera's about to die. I took pictures before I came in this morning. I've had a couple of guys, my daughter-in-law's been in charge of everything. 'Cause I've got a family member at home. He's an invalid, so I have to do everything for him, feed him
No, I
and
get
all
it.
that. But I'm not trying to make an excuse.
Well, 30 days doesn't sound unreasonable. I would just need to see the photos. So let me know if you have any objection to those being evidence, and then we'll admit them as evidence.
No, I don't have it. This is all mine.
Okay.
Except for that stuff back there.
Well,
that's not my house. Yeah, it was a mess. I mean,
Are you
I've had a
keeping
lot
these in order,
I've had
by
a
the
lot of
way?
things going on.
Okay, okay. All right.
I don't even see
All
it.
right, so you don't have any objection to them being evidence in this case? All right.
Sure.
Is there anyone from the public who wants to be heard on this? What's the county's recommendation?
$150 a day along with the administrative costs.
Okay, I'll just take a look at the photos before giving it time. And Mr. Charlton, I note on the agenda, under the abated and continued cases, there's something that just says Trinity. Is there someone, is it like Trinity from the Matrix? Is it just one name? I mean.
What's that?
We're having IT issues.
Oh, okay, I was just curious. It's.
On the minutes, it'll be spelled out.
Okay. Do you have any health, safety, sanitary concerns?
No.
All right, then I will find that there's a violation. I'll give you 30 days to bring the property in compliance, and if it's not brought in compliance as ordered, $150 a day.
Yes, sir.
Good luck.
Thank you.
Next case, Rains Investment LLC, case number 2024-415. Licensing Compliance Officer Kim Slater, page 26 of your agenda. Expert on the case, Samuel Costa, Building Director.
Kim?
Sorry.
It's okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am.
Welcome, Ms. Slater.
Hi.
Welcome.
Good
Yep.
morning. Kimberly Slater, Citrus County Licensing Compliance Officer. Case number CE 2024-00415, Chapter 18, Article 1, Section 18-8A. Obtain after-the-fact permits for all construction or modifications of the Citrus County Code Compliance of Ordinances. Address is 10 South Fillmore Street, Beverly Hills, Florida. owner Rains Investments LLC, good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos taken during my initial inspection on March the 7th, 2024. Photos taken at my corrective action follow-up inspection on May 2nd, 2024. And photos taken at my final inspection on June 18th, 2024. Exhibit B is a copy of the notice of violation, a copy of the copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt indicating good service dated May 17th, 2024.
Okay. Is anyone here from Rains Investments? Are there any folks from the public who want to be heard on this? Okay. Then, without objection, I'm going to admit Exhibits A and B as evidence, and I'd like to take a look at them.
Sure.
Thank you.
No, you don't have to wait.
All right. All right, so what's going on here?
It's a rental home. The tenant allowed me access because she was the one that actually called and complained because it was an after-the-fact permit for that's what we determined, 2 mini-split AC units installed, one being in the living room, one in the master bedroom. It's a mess, as you can well see by the photos.
Yeah, wow.
However, like I said, it's a rental home. The actual
have you had
AC
contact with the owner?
No, sir, I haven't.
Okay.
It had an AC unit that was not working, that was located in the hallway of the home. However, the landlord opted to have these installed.
Has it been vacated since you started this case?
It was vacated and re-rented. I was out
Oh, wow.
yesterday, and there's a new tenant in there.
Okay, wow. Is there any AC for the property?
It's the
that-
same.
That works?
The same 2 mini splits.
Okay. And this is the kind of work that would require a permit?
Correct.
And there is no permit?
No, sir.
Is there any
And it would
application?
be, but since it's in an LLC,
Mhm.
the property as owners in an LLC that can't pull the permit themselves, they would actually have to have a mechanical contractor. And by the photos that I can see or that I've witnessed, the electrical portion would also require a permit.
Okay. What's the county's recommendation?
County's recommendation is, where am I supposed to start at? Citrus County Licensing Compliance Division respectively requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given to severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that the respondent's responsibility to contact the License and Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, $100 a day.
Thank you.
Thank you.
Next case on the agenda, Lisa Shepherd, case number 2024-329, Code Officer Brandon Norman, page 29 of your agenda. Okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please?
Lisa Shepherd.
Thank you.
Good afternoon, Ms. Shepherd.
Hi.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 202400329, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 8516 East Aquarius Drive, Inverness, Florida. Property owner listed as Lisa Shepherd. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 23rd, 2024, a corrective action inspection done April 22nd, 2024, and a final inspection done on June 17th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
All right. Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And also let me know if you think agree that there is a violation.
Well, there's a violation.
Okay. Well, how much time do you need to fix
He's
the
not crazy.
How much time do you need to fix the violation?
I have done a lot of work,
Mhm.
and there is still a little bit to be done.
Mm-hmm. I mean,
But
is it a
it's
30-day
almost
job? Is it?
30 days.
It's a 30-day job.
And I can see you took some pictures not too long ago as well. Because I just got my truck back last month, and that it would have been easier with my truck to get
Mhm.
it done. And the girl that returned my truck, lifters are making noise, so I can't even hardly use my truck. I definitely can't use the trailer in the truck because I don't want to mess up my truck.
What's the county's recommendation?
The Citrus County Code Compliant Division respectfully requests the special master assess a fine of $50 per day along with administrative costs beginning after the day that you deem sufficient. This amount was selected based on the actions of the property owners. Once they revise the violation, it's appropriate given the severity of the violation and the respondent's actions.
Do you have any reason to believe that she can't get it done in 30 days?
She's been making progress
Okay.
continually. She's been in contact with me. She's
Okay.
been polite
All right.
and understanding as well. so.
Is there anyone from the public who wants to be heard on this case? Well, then, Ms. Shepherd, unless you have an objection, I'm going to grant you 30 days from today to abate the violation, and if it's not brought into compliance as ordered, it'll be a $50 a day fine.
All right, and can I ask about, like, all that carpet and stuff is gone, but, like, the planters that are cloth, those are still good, right? I can have those.
Are planners a part of the violation?
My stance is it's the same for everyone. If it has an outside purpose, it's allowed to be outside. If it's not, if its intended use isn't for outside purposes, it needs to be either stored or
like
disposed of.
vegetables or whatnot. All right, and then, I do have still, this stack of wood is still there, but that's just.
That's fine.
Okay, that's
Mhm.
fine, okay.
Just know that some of the violations.
So I don't hear any objection to the exhibits. We'll admit them as evidence. You've got 30 days. If it's not brought into compliance in 30 days, it'll be a $50 a day fine. All right? Thank you.
Thank you.
Next case, Michael Edward Butts, case number 2024-757. Alan Jonason is the code officer, page 5 of your agenda.
They've been saving you till the end of these hearings
Yes,
lately,
sir.
Mr. Jonason.
Best for last. Best for last, sir.
Do I get a vote?
You get to swear me in.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Good afternoon.
Good afternoon.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00757, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 3506 East Gulf to Lake Highway in Inverness, Florida. Property owner is Butts Michael Edward. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 23 April 2024, photos from a compliance inspection on 23 May 2024, and photos from my final inspection conducted on 18 June 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Okay. I don't see any other members of the public, so I won't be asking for their comment anymore unless I see someone come in. What's been proposed as Exhibits A and B are evidence.
On 23 April 2024, I conducted my initial inspection and observed the property to be in violation. On 23 April 2024, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 23 May 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 18 June 2024, the property remains in violation.
So it seems like most of this is the tires, right? I mean,
There's
it's-
other stuff
yeah.
too. If you look on yesterday's photos. Now there's a bunch of cardboard boxes and stuff off to the left. I think it's the first picture in the stack there.
From yesterday?
From yesterday, yes, sir. There's a bunch of new stuff there, and I have no idea where that came from.
Let's see. Oh, I see. Well, that's
Yes, sir.
certainly junk.
Yes, sir.
I guess I just want to establish, though, it's a tire business of
It
some
is-
kind, right?
It is closed, though.
It's closed.
The business is closed.
Even if
yes,
it was
sir.
operating, would they be allowed to do
No,
this?
sir, those
Okay.
have to be inside of an enclosed building.
Okay.
And because of that, we are requesting a $200 a day fine because of the health hazard with mosquitoes and such, especially with the rainy season, hurricane season.
I agree with that. That's in every mosquito control training.
Yes, sir.
All right, then I'll grant 15 days and $200 a day.
Thank you.
All right, thanks.
Next case, Dustin, Caitlin, Dylan, and Nathan Erie, case number 2024-699, Code Officer Alan Jonason, page 12 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00699, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address of the violation is 1756 North Paul Drive in Inverness, Florida. Property owners are Erie Dustin, Erie Caitlin, Erie Dylan, Erie Nathan. If I'm mispronouncing that, I apologize. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 11 April 2024. Photos from my compliance inspection on 2 May 2024. And photos from my final inspection conducted on 18 June 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
All right, without objection, what's been proposed as Exhibits A and B are evidence? Thank you. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the Special Master assess a fine of $100 per day along with administrative costs.
I mean, it's really self-evident from the photographic evidence.
Yes, sir.
Have you had any contact with the owners?
I have not.
No? Do you know if anyone's there?
It doesn't appear to be lived in, but it's hard to tell.
Fair enough. I'm going to give 15 days and $100 a day.
Thank you.
Next case, Homosassa Investors LLC, case number 2024-513, Code Officer Julie Wilkinson, page 18 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 24513, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4500 South Suncoast Boulevard, Homosassa. The property owner is Homosassa Investors LLC. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 21st, 2024, a corrective action inspection on April 30th, 2024, and photos of my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the general pre-hearing order, and a copy of the signed certified mail return receipts.
Without objection, it's admitted as evidence, Exhibits A and B. Please, well, it's also self-evident from these photos. Have you had contact with the owner?
No contact, but I've had good service for both the property appraiser, listed owner and the registered agent. And
I mean, it's a shopping center, right?
Yeah.
I mean, it's odd. It's really clear that there's junkyard conditions from the photos on the dates that you took the photos. And what's the county's recommendation?
$150 a day, along with the administrative costs.
Okay, on this one as well, I'm actually gonna give 15 days, and what was it,
$150.
$150 a day?
Thank you.
Thanks.
Next case, Mark Allen Murphy, case number 2024-821, Code Officer Cody McGuire, page 21 of your agenda, expert on the case, Joanna Coutu.
Cody McGuire, Citrus County Code Compliance Officer, case number 202400821, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 11734 North Citrus Avenue, Christian River. Property owner is Mark Allen Murphy. Goods service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on April 25th, 2024. Photos taken during a corrective action inspection on May 10th, 2024. And photos of my final inspection conducted on June 18th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay. What's been proposed as exhibits A and B are evidence. And please proceed.
On April 25th, 2024, I conducted initial inspection and observed an RV, multiple vehicles, including a trike, enclosed trailer, and other items on vacant property. On May 10th, 2024, corrective action inspection was conducted with little to no change. I've had a contact with a man named Robbie who states he is a property owner, and he is actively working on cleaning it up or removing the items.
Did he say how much time he needed?
Late yesterday, he called for a reinspection after I was already out.
Okay. I mean, it's Ms. Coutu, did you want to testify or feel the need?
I don't need anything. All it is construction to bring
You
a
don't
bird
need-
cage.
Okay.
I'm sorry.
No, well, okay. I mean, it doesn't seem like it'd be that hard to fix. I will grant, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based off the actions of the property owners once they were additionally fined, or property owners once they were advised of the violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I'll grant 30 days, $50 a day if it's not brought into compliance.
Thank you.
Next case, Power Sports of Minnesota Incorporated, case number 2024-192, Code Officer Julie Wilkinson, page 24 of your agenda, expert on the case, Joanna Coutu.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 24192. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 10671 West Marker Path, Homosassa, Florida. The property owner is Power Sports of Minnesota Incorporated. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 7th, 2024. Photos taken during a corrective action inspection on April 26th, 2024. And photos of my final inspection conducted on June 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt. One second, I pulled the paperclip off.
All right, what's been proposed as Exhibits A and B is evidence. Go ahead.
All right. On February 7th, 2024, I conducted an initial inspection and observed a hot tub, dock, canoe, barbecue grill, lumber, furniture, miscellaneous junk debris on the property. On February 8th, 2024, a notice violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On April 26th, 2024, it conducted a corrective action inspection and found that some items have been removed from the property, but the property remained in violation with the dock remaining on the property. I have had contact with Mr. Rose, extensive contact, who had told me that there was a home on the property, but they had it removed and they're planning to build a new home, but are having difficulty getting a permit approved. As of my final inspection on June 18, 2024, the property remains in violation. My expert on the case is Land Development Director Joanna Coutu.
I would like to speak on this one. They applied for a variance for wetland setbacks. It was denied by the Planning and Development Commission on January 4th of this year. So we have no active permit applications to review. He was not happy. They were denied, of course, but we have no applications or follow-up.
I have a couple questions about this. So
Sure.
you said wetland setbacks?
Wetland setbacks,
So
right.
is there a greater setback because there's wetlands, or what does that mean?
It's similar to waterfront, except a little bit more. Waterfront, you can actually do an average. Wetlands, it's much harder. So wetlands is a 35-foot setback. And in this, almost all of the site is wetlands. A prior owner did get fill on there with DEP, some enforcement action, et cetera. So there's a little tiny gravel area in the center.
That's buildable, or?
That could be buildable, but his house wanted to go outside of that, and the Planning and Development Commission did not approve that.
Did staff recommend denial?
We don't really make a recommendation, but you could put a house there and tighten it a little bit. We were kind of on the fence.
So it's residential
It is
zoning?
absolutely residential, and I think he can get something there eventually. He just needs to try to design. It's a little bit constrained.
Okay, all right. How big is the parcel? Do y'all know?
It's 0.29 acres.
0.29, okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. We also asked the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
When was the variance denied?
January 4th.
Oh, okay. So y'all didn't really start the case until they were denied? Or were you waiting for it to be resolved?
As soon as I get a case, a complaint in, I go to it as soon as I possibly can.
Okay. No, I was just curious the logistics of it. And you don't know whether he's going to apply again. He said that he would.
He said that he would.
If he did get a variance alone wouldn't bring the property into compliance, right? He would need to actually get a permit.
He would need to have a structure on the property.
The principal use.
Yes,
So it's not, even the permit's not enough.
exactly.
Okay.
And I think because of the constraints, he's going to have a variance before he can get a permit,
Right.
unfortunately.
Okay. Then,
The much faster option is to just remove the stuff that's on
oh,
the
no,
property.
for sure. I know. I was just trying to think about.
Could I also add a little bit of something?
Yeah.
So he's also kind of making it difficult with, he's disagreeing on what needs to be removed. He's saying that the dock can stay on the property, but it can't according to our code. So I just wanted to put that on there to make sure that's
It's really
specifically
clear in
mentioned.
the code that
Yeah.
it can't remain. I'm going to grant 30 days, and if it's not brought into compliance in 30 days, $100 a day.
Thank you.
Yep.
Next case, Precise Property Management, case number 2024-439. Code Officer Brandon Norman, page 25 of your agenda. Expert on the case, Joanna Coutu.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2024-00439, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102A. Address is 10022 East Bass Circle, Inverness, Florida. Property owner listed as Precise Property Management. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during initial inspection on April 19th, 2024, corrective action inspection on May 16th, 2024, and my final inspection June 17th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Okay. What's been proposed as Exhibits A and B are evidence. Okay.
On April 19th, 2024, an initial inspection was conducted of the property for storage on a vacant parcel. The property was found to be in violation with a mobile home and no CO issued. A building permit was issued on June 29th, 2023, and expired before being finalized on December 26th, 2023. The last action on the permit was on June 29th, 2023, for a commencement notice needed to be submitted. The property remained in violation at my notice of violation corrective action inspection on April 22nd, 2024, or I'm sorry, May 16th, 2024, as well as my pre-hearing inspection that I conducted on June 17th, 2024. I have not had any contact with the property owner. The mobile home continues to deteriorate since the installation was never completed and is beginning to scatter debris around the neighborhood.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $300 per day along with administrative costs, and that respondents be responsible to notify us once it's been completed.
Okay, on this, I'm going to do 30 days and $300 a day if it's not brought into compliance.
Thank you.
We have one more?
One more.
Okay.
Two more.
Two?
Yep.
Wait.
NVS and Spofford.
Yep, okay,
Oh.
thanks. Yep.
MVS Homes Pro Services LLC, case number 2024-440, Code Officer Brandon Norman, page 22 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is case 202400440, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 100 East South Lake Drive, Floral City, Florida 34436. Property owner listed as MVS Home Pro Services, LLC. I have good service via posting of the property in the Lecanto Government Building. I'd like to authenticate the following and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on March 14th, 2024. Corrective action inspection on April 22nd, 2024. My final inspection done yesterday, June 18th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing of the property.
Right. What's been proposed as Exhibits A and B are evidence.
On March 14th, 2024, I conducted an inspection for a complaint of junk and debris. I found the property to be in violation due to improperly stored junk and debris and household trash throughout the property on the rear side. The property remained in violation of my corrective action inspection on April 22nd, 2024, and as of June 18th, 2024, the property remains in violation. I have not had any contact with the property owner. There do appear to be squatters on the property, and they are a severe nuisance to the neighborhood by burning trash and being disruptive to everyone else around.
You have any other cases on this property?
We had initial cases prior to, they did get brought into compliance.
Wow, okay.
I'm not sure what's going on right now.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $200 a day along with administrative costs to begin after the date that you deem sufficient, and that the respondents be responsible to contact the Code Compliance Division once it's been completed.
Okay, 7 days, $200 a day.
Thank you.
Last case, Frank Spafford, case number 2024-455, Code Officer Brandon Norman, page 30 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 202400455, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for 5 North Shadowwood Drive, Inverness, Florida. Property owner listed as Frank Spafford. I have good service via signed certified mail return receipt, and I'd like to authenticate the following documents and request they be admitted to evidence. Exhibit A will be photos taken during my initial inspection on March 11th, 2024. My corrective action inspection on April 22nd, 2024. My final inspection done yesterday, June 18th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B will be admitted as evidence.
On March 11th, 2024, I conducted an inspection for a complaint of junk and debris, and I found the property to be in violation due to improperly stored junk and debris and household trash throughout the property. The property remained in violation of my corrective action inspection on April 22nd, 2024, and as of yesterday, June 18th, 2024, remains in violation. He is getting close to completion. I have been in contact with him. He's been very polite, very receptive, and doing everything he can to bring the property to compliance.
How big is this parcel?
I don't have it right in front of me, but
I mean, it looks bigger than a quarter acre.
it's a little bit bigger than a quarter acre, but he doesn't have much left to do.
Okay.
We've talked about it. He completely understands what we're asking him to do. He's going to do his best to get it done.
What's the county's recommendation?
Recommend $50 a day along with administrative cost, and that he contact us once it's been completed.
I'm going to grant 30 days and $50 a day if not brought into compliance.
Thank you.
Now, next item on the agenda, we don't normally do anything, but it says other business. I do want to ask the county two questions. One is, I would like feedback from the county's perspective, from an enforcement perspective. You know, if you look at code enforcement around the state, different special masters and special magistrates give different times for compliance. I very often see 7 days, 10 days, 14 days. Here, the custom, when I watched Brennan before I became the main special master, it was very commonly 60, 90, 180, 360, you know. And I've moderated a little bit, but not a whole lot. Usually it's 30, 60, stuff like that. From a county perspective, I've never heard any feedback. I'm interested to know the county's perspective on this. Does the county have a position on what should be customary times or what works better from an enforcement perspective?
Based on the respondent's actions, once we notify them, if they're, you know, working with us and explain, you know, what may have be hardships and what violation, because each case is going to be different. It's going to be, you know, case to case, on a case to case basis. But shortening the time definitely helps with enforcement. Absolutely, it does. And based on, especially if it's a bad, you know, junk and debris case, then, you know, once they start getting those fines, then we can go to other areas of enforcement after that.
Well, what do you find, like if there's a really bad junk case, and let's say I give 60 days, because it's just a lot, usually I make the finding based on the fact that there's some testimony about financial hardship or something like that, but is it your experience that really it could be done in 14, even with those kinds of hardships, or that it would get done?
In some circumstances, yes, because there can be a hardship, but in some circumstances, it may not get done anyway, if you know what I mean.
They do have to pay for disposal here, correct? Like to take it to the junkyard. A lot of stuff, like if it's, do you know how much that costs?
No, but if they are a resident of Citrus County, they don't have to pay as much.
Okay. The second question relates to the actual amounts of the fines. You know, years ago, you had the Hammer as your special master, I believe, Michelle Lieberman, and that's, and she was issuing orders. You know, she made full use of the range of fines available to the special master, and she believed in that. She's a great lawyer. My predecessor kind of went back towards the other direction. I think I'm closer to him than I am to Lieberman, but I also was wondering from a code perspective, what do you find does a higher fine lead to more compliance or quicker compliance, or is there anything I should know or that you'd want me to know about different fine amounts from your perspective?
With the fine amounts, I think some of that is going to be based on our contact with them also and the case. And absolutely, we should be asking for more based on the case and our recommendation for that
part of why
fine.
you ask for certain things is you know what I'm doing. So that's why I'm trying to signal that I'm open to different things, but I want to know what works and what doesn't from your perspective.
I'm not opposed to raising, giving them stricter.
But do you find better compliance when it's a higher
At times, yes.
I mean, it's up to y'all. And I don't want to. I mean, if you're allowed to speak, you can speak.
Yeah.
I mean, I don't want to.
Yeah, go ahead. This is for everyone.
There's a chain of command, so I don't want to.
No, this is
You are
for.
still on YouTube though, so.
Yeah, we're on YouTube.
So I have noticed in other cases where I do have to take it to a citation hearing, these fine amounts do come into consideration when the judge is looking at the case. I just took one case where the actual fine amount was almost as much as the property's value. So he gave them a shorter amount of time in order to bring it to compliance on his order based on that finding.
Wait, can you tell me about that? I'm not familiar with that hearing.
Certainly.
Kind of a hearing.
So when we have a case, right, that never gets brought into compliance, and we get a new complaint for it, we issue.
So you're saying there's already been an order.
Already a junk
The fine's
case.
been accruing for
Mhm.
years.
Right.
There's another case.
Another case now. I issued a citation. We went to hearing. The amount of the fine that had incurred over the time for us for the lien was almost as much as what the property
Right.
was worth, and the judge actually took that into consideration, I feel like. And
How did the
gave him a
judge
shorter
take
time.
it into consideration? Like
Uh,
what?
Just when I did my testimony, I explained to him that, hey, this is what our lien is for. This is how much they've incurred so far, and it still hasn't been brought into compliance, and there still is no change. So he seems to take that into consideration when we present that kind of information to him.
What kind of remedies, like what does a judge order in that kind of a hearing?
So he'll order them to clean it up within, 30 days or whatnot, and then they have to pay the civil citation.
Yeah, okay.
And then if they don't do that, then
I see.
essentially it's we go back and
contempt hearings and
a
they-
contempt
Wow,
hearing.
okay,
Yeah.
okay.
We've actually put somebody in jail before.
Yes.
For failing to comply with.
When
the
was
citation.
that?
When was he last?
Yeah.
Really?
I've had a couple.
Yeah.
We've done a couple.
It was
Contempt,
couple
Yes.
contempt.
times.
I mean, are those only health sanitary cases, or do you? Wow,
And
like someone didn't mow their lawn.
And we
haven't had a lot
I'm
of
just
cases.
joking. Yeah.
No, it
Okay.
hasn't.
Okay.
It's usually junk and debris.
Okay.
But that's
Is there?
only after we've done everything that we can to, to get compliance, and they don't
Mm-hmm.
comply.
And the judge, has been, he'll give them 30 days, and then when we do the contempt, everybody has to show up, they have to get notice,
Mm-hmm.
then he resets it, so they're getting that more time the
Yeah.
whole time. And then the PD has to be appointed usually,
Mm.
and a lot of times, there could be a conflict, so they get another continuance. So even though they're ordered 30 days to clean it up, by the time they actually get to the contempt hearing where they could be put in jail, it's 6 months later, so they're actually getting.
Right.
And if they clean it up in that time, the judge is very
Yeah.
lenient and say, no, we're not gonna put them in jail. for
Discharge
that." But
contempt,
it's-
yeah.
I'm at almost a year on one case. That's at citation hearing.
Is there anything else you think I should know from your perspective in how we handle these hearings, or that you'd want to change or adapt procedure-wise?
Can we recommend how much time it should take to
That's
be
up to
brought into
y'all. I mean,
compliance?
I make no position on that. That's up to county, but
Can we just add that in there into our little, based on what we've experienced with them?
I think from our standpoint, we'd have to, testify to it, better, our contact with them. How's that been? How are they willing?
that's
Have
useful
they-
for
have
me.
they-
That's very useful for me because I care about that in terms of the aggravating, as well as mitigating. If they're cooperating, I don't want to punish someone for that. On the other hand, if they're really uncooperative and saying certain things, I would probably need to raise the fine to ensure compliance. So.
And taking them, even though they've abated the violation, and since we've started doing that, has helped, because then that gets that repeat, and then they clean it up quicker once that repeat
Right.
starts.
There's a lot of counties that don't care if it's brought into compliance by the time of the hearing. They just go ahead and get the finding. Of course, I, as someone who sometimes represents owners, don't like that. But it's an option that y'all have that may be a good compliance tool. Something that I think would be helpful is maybe have a projector where you can put something onto a screen. It may be difficult to constantly get things on the computer screens, but even just a projector, like we had the issue today where we all weren't on the same page, but it's cheap, they're around and they don't use them in schools anymore, so.
You'll see it next month in my
Made a note
case.
of-
Yeah, well, it's just an idea. But is there anything else? Okay, then time is 12:37. This hearing's adjourned.